Item number 3, 4, and 5. Lord will withdraw, madam.
Withdraw?
Yes. I will approach the arbitration, madam.
Mr. Kane Chaudhary, the learned senior counsel, assisted by so and so.
R. Kapati.
Or Mr. Kane Chaudhary, the learned senior counsel, assisted by so and so. And Mr. K. Kulta appearing on behalf the standing counsel of Oil. Mr. Kane Chaudhary, the learned counsel, senior counsel submits that they're taking into account the materials. The petitioner would be well advised to take steps, take recourse to the arbitration clause in view of the limited jurisdiction available, in view of the narrow compass in which proceedings under Article 2 to 6 is to be carried out. Taking into account the above submission, the incident with petition therefore stands close on withdrawal without prejudice to the petitioner to invoke the arbitration clause if so advised.
Deployment.
There will be 3 separate orders?
Yes, yes.
I'm praying for listing lordship to matters and admission column lordship.
Huh?
I'm praying for listing two matters in admission column lordship.
When?
Lordship on Friday or Monday lordship. Regarding non-payment of
Friday? Why?
non-payment of contextual dues since long lordship.
Contractual bills will always, what is the urgency?
Agency
Have it next week.
next week any day lordship. Of last.
Next Wednesday.
Let me appeal the lords. But despite honorable court's direction, my lord, the CO, my lord, has allowed that explicitly in terms of government notification to run a market during pendency of till final settlement, my lord, which has already been barred by this honorable court, my lord. So I have filed a petition in this regard yesterday, today, my lord. So let the matter come tomorrow, my lord. I love it.
For admission, item 6.
With Mr. Lordship. Lordship, instruction is awaited in the matter, Lordship. As to why the bill has not, the contractual bill has not been paid, Lordship. I'd like to.
What time?
Very much.
Why?
Lordship, instruction is awaited, Lordship. We'd like to pray for some further time to file an affidavit.
Notice was issued in 2024. You still don't have instructions, meaning thereby these people are not taking care of, means they are not abiding by what you are asking. So we do one thing. We direct this official to be appearing before this court personally.
Lordship, last chance,
No, this is
Tuesday,
the best way out.
Tuesday, Lordship.
Who is to make the payment? Payment has to be made by whom?
Executive engineer.
Respond number 5, health service. So Joint Director of Health Service, if he is not inclined to give you instructions, even after a passage of 1 year,
Lordship,
I
last-
think he is not entitled to have the benefit of a lawyer. Isn't it? So we ask him to be present in the court to the video conferencing link, answering why he has not provided the inputs as to whether the petitioner is entitled to the amounts owed. I think that is the best.
Lordship, last chance can be granted. On Tuesday, we'll bring the instruction, Lordship.
Friday.
Friday,
Last chance Friday.
Lordship.
Miss,
S. Kemprai, Lordship.
it's S. Compare. The learned counsel appearing on behalf of the respondent number 3, 5, 6, and 7 submits that she would obtain the instructions as to whether the petitioner is entitled to the amount of rupees 10 lakhs as claimed in the instant writ petition.
Six.
As well as when the said, and if so, when the said amount would be paid to the petitioner. This court finds it very pertinent to observe that the instant, in the instant writ petition, notice was issued 1 year back, and the counsel appearing on behalf of the respondent numbers 3, 5, 6, and 7 has apprised this court that no instructions have been provided by the said respondents. It is observed that if no instructions are provided on the next date so fixed, this court would be constrained to pass appropriate directions seeking the appearance of the respondent number 5, under whose agents, AEGI, the work order was issued in favor of the petitioner to the petitioner. First, list this matter on by state.
I move that. Item 7.
Here, may pass over for the time being, my lord, senior counsel, my lord, in question number 5 and 8.
What? October for the time being, or whose?
And from the petitioner.
Huh?
Petitioner. My lord, senior counsel, my lord, can say.
Who is this senior killer?
Can so, my lord. Petition court
He has
number-
just left.
Yes, my lord, court number 5, my lord, time being.
He should have withdrawn 3, 4, 5 years withdrawn. He should have withdrawn the 6, 7 also.
There is an interim order operating where we have filed an application for vacating that interim order.
Okay. If he is not arguing, you argue.
My lord, here it is a case.
Our part, my lord, senior counsel will cut. My lord, my.
For delivering the judgment, dictating the judgment, if your senior arrives, very good. If not, I will say that the counsel for the petitioner did not wish to argue, and the counsel for the respondent argued.
My lord, here in this case, one NIT was issued for hiring of tankers, water tankers by ONGC, my lord. Now, the petitioner submitted his bid and he was given an N-way. Why he was given the N-way? There was a tie. Because of the tiebreaker condition, which says that the one who promises to supply it at a lesser period of time, he will be given. So initially there were
And who promises to?
supply the tanker, new tanker within a lesser period of time. So here the petitioner was allotted the work on the ground that he bidded for a period of 59 days within which he could
He will be providing the tanker.
tanker. Now, NOA was issued. He did not provide the tanker,
Finished.
terminated. Now, as a consequence of termination, he in the bid agreed that he will go by the general conditions of contract. Condition of contract says that if a contract is terminated, then as a consequence of termination, they can proceed for blacklisting. Accordingly, a notice was issued initiating the process of blacklisting, and there was a provision in the GCC that pending inquiry, he can be provisionally blacklisted. That is under challenge, my lord. Now, my lord, what happened? A writ petition was filed. That writ petition was allowed in a different context where the tender was under challenge. But the termination took place prior to the issuance of this order in the writ petition.
What petition? Who filed it?
Another person challenging the NIT. During pendency of that writ petition, the NOA was given and others were also given.
Let's see that order.
My lord will find that order. Lordship may take note of the fact that
71.
272. WPC 5870/23.
He
Not-
filed it.
No. Now, the interesting part in this writ petition, he is saying that the allotment itself was illegal. He is questioning his own allotment.
Because he is the same counsel who is arguing in both matters.
Exactly. My lord,
Have you? Have you
It-
seen the question?
in the other writ petition, it was filed by another person,
Cartel?
my lord.
Cartel? Cartel is included in the
Lordship,
same counsel.
lordship will have a look at the
And you are the
NOA,
you are the counsel for both the parties.
my lord.
Now,
My lord may have a look at the NOA, which is, your lordship will find at 234, 238 page number in the writ petition. It starts from page 236. If your lordship comes to page 237, it is dated 4/10/23. Why I'm putting the dates, my lord? Dates are very relevant for this case, my lord. 4/10/23 at page 23, 237, your lordship will find mobilization period. 59 days from the date of issue of NOA. In case the contractor fails to mobilize the water tanker within the mobilization days, the NOA will stand automatically cancelled and ONGC will take recourse to action as per conditions of the tender.
now finally come to page 275.
Well,
This is in respect to the same tender.
my lord.
Now, in that same tender, there is a direction that the entire tender process, that
A fresh tender.
the rejection of the technical bid of the petitioner was incorrect.
My lord.
And as such, directed that there shall not be, the respondents are directed not to issue any notification of award to any bidder in respect to NIT dated so and so, insofar as it relates to Sibsagar district.
My lord, there is a in development which we have projected in our IA vacating the state.
Understood? Did the
Already that
petitioner-
NOA was
did
issued.
the petitioner apply for the Sibsagar district?
My lord,
Same.
my lord. NOA was issued on 4/10/23.
Understood. You have issued an LOA, but there is a direction not to issue an award.
My lord, this NOA, on at least, my lord, on this day when this order was passed, that NOA was already terminated.
LOA was terminated, understood everything. But the fact remains that there is no award is to be passed.
That is what I would like to clarify, my lord. There is this part has not been stated in the writ petition. We have projected what happened after that NOA was issued. They filed an application for setting aside that NOA. This honorable court passed an order. Lordship will have a look at that order on 10/11/23 at page 34 of the IA, where it was
Of
clarified.
this court,
Yes,
of this present proceeding.
yes, ma'am. IA 3297.
What is it? Order dated,
Page 34.
order dated
My lord, order dated 10/11/23.
10/11.
23. And
This IA was filed in 2024.
yes, no, this IA was filed at the time when the NOA was issued. What
The
are
earlier one,
earlier one,
yes, page,
page 34. An allegation is raised by so-and-so learned counsel for the petition that having regard to the interim order dated 4/10/23, which provides that till 6/10/23, the IOC authority shall not undertake any further process in terms of the price bid, so-and-so, so-and-so. So-and-so learned counsel for the respondents, ONGC denies the statement. Without going into determination as to whether a work order is issued, we clarify our interim order dated 4/10/23 that the expression shall not undertake any further process means if the work order was not issued as on 4/10/23, the same shall not be issued, and if issued, it shall not be acted upon. We also clarify that the interim
so
order.
it shall not be acted
My
upon.
lord, the next line, we clarify that the interim order dated 4/10/23 shall be in respect of only those tenders where the petitioner had participated. Now, my lord, there are 8 tankers for which NIT was floating. The other 8 petitioner had submitted his bid in respect of 2 tankers. So, in view of this,
We are concerned as to whether the tender which was floated with this petition, present petition, participate in respect to Sitagar.
my lord, this tender was not in respect of Sipsagar, my lord. It was a general tender.
Here the order has been.
My lord, that is,
The issue, the respondents are directed not to issue any notification of award to any of the bidders in respect to the NIT insofar as it relates to Sipsagar.
that NIT was never relating to Sipsagar. It was a general NIT, my lord.
Then how do you reconcile this order?
Now, what happened, my lord? This order, the other bidders who were issued NOA, there were total 8 tankers in respect of 6 NOAs were issued. This petitioner failed to perform his part, for which that NOA was terminated. But the other persons who were issued NOA approached the division bench.
When did you terminate this contract?
My lord, on 16/1/2024, and this order was passed on, my lord, this order was passed on 26/24. That is after 5-6 months of the termination of the NOA. So, my lord, the question which calls for an
Let
answer,
us see, therefore, his judgment will have importance.
my lord, what happened? This judgment was challenged by the other successful bidders, and that is an interim order passed by the division bench.
Wait. Let us read 272. First, what is this NIT bids?
My lord.
NIT is at page 30.
Yes, it starts from page 30.
For submission of bids are downloadable against RFX number R16 so and for your e-procurement description. So and so period of sale of the bidding, well, so and so date of submission, date of inspection of.
So this NIT was never for any Sipsagar district or some other specific any district, my lord. It was a general wherein ONGC wanted supply of 8 water tankers. There are 2 categories, 3 categories, my lord. One is old tanker, another is new tanker. So all relates to new tanker.
What is TBO date?
My lord,
TBO.
EBO,
60/2023, my lord.
6/3. 6/3/23. My lord, there is an order passed in by the honorable division bench, my lord, connecting to that cancellation order, which will throw some light to your lordship's query. Which your
What is
lordship,
this clause C2? Where do I get that?
my lord,
Page 200, my lord.
C,
Fourth paragraph of clause C2,
Page 200, my lord, is petition.
Huh?
Is petition, my lord, 200, page number 200.
page 200.
C, আছে?
200, yes, bid submission is here. C2, the bids will be evaluated based on the calculated lowest monthly output as per the prices quoted by them. Quoted demand, bidders to quote that quoted rate exclusive of demand and should not be. Bidder to note that the quoted basic running price of the should not be less than 0.2 diesel sector declared by for Sipsagar as on TPO date. TPO means tender bid opening date. So therefore, this Sipsagar rate, how will these bidders will know that what is the rate?
From the official IOCL,
No, it is, you see, the bidding, the tender opening date means
6/3,
declared on the tender bid opening. What is the date of tender bid opening?
6/3/2023.
Where do I get it?
First page, page 30.
Tender
Date and time of opening of techno-commercial unpriced bids, 6/3/2023.
opening, 6/3. And this bid was, invitation was given when?
My lord, invitation was given,
When was this NIT floated?
my lord.
Okay, the period of sale was from 12/3. Last date is of 6/3.
Yes,
Okay, so last date of submission is 6/3.
my lord.
Now, how will a person know if he does on 6/3, 5/3? He could submit on 5/3 also.
He can submit on 6/3 also.
He can submit on 6/3 also, but he can submit on 5/3 also. If he submits on 5/3, how will he know what is the rate in respect to the rate declared by the IOC?
On the day he submits, he will get a list from the IOC website, what is the rate.
Bidder to note that the quoted basic running rate per kilometer exclusive of applicable GST should not be less than 0.275 into diesel rates declared by the IOC for Sipsagar as on TPO date. So the rate has to be on 6/3. So, but he could submit on 5/3. But he has to quote cannot be less than 0.275 into that rate.
Here, my lord.
But he has to assume that
My lord, the
the
rate-
IOC would do this. Because you see the Sipsagar issue, why it has been made, it couldn't have been Sipsagar. The last line out here in paragraph number 12 of the order passed by the learned coordinate bench have to be read or understood in that context. Award to any bidders in respect to the NIT insofar it relates to Sipsagar district. Insofar as it relates to Sipsagar district has no meaning. Because it could not have been Sipsagar, because as per your tender condition, the IOC or ONGC, who have IOC, na? The
Wait.
IOC would declare
The rate.
the rate for Sipsagar. The rate of diesel rates
Diesel.
declared by IOC. So he will declare the rates as on 6/3. So therefore, the for Sipsagar means what? What do you mean by word for Sipsagar?
The rate which is applicable at Sipsagar.
Why would it be different in Sipsagar and in Nazira or any other place?
That I do not know, my lord. But the issue here,
No, the issue is here means how do I interpret the last line of
No, my
paragraph
lord,
12?
that is why, my
Paragraph
lord,
12,
there is,
the
the
last
matter
line, this
is,
has a relevance because all these actions were taken during the pendency of the writ petition.
Ma-
So any decision in the writ petition will have an impact. Maybe there is an interim order, may not be an interim. Initially, there was an interim order. Then the other next order, which has been passed by another coordinate bench, also makes it clear that, okay, if you have not issued the tender, not issued the LOI, no problem. don't issue. If you have issued the LOI, but don't go ahead.
But only in respect of the bid submitted by that writ petitioner. That means he submitted bids for 2 tankers. That is why
I'm not
out of it-
concerned with the 2 tankers. That is the question is, as per the notice inviting tender, you could quote for 8,
8 or minimum 1.
minimum 1.
My lord.
So there cannot be a generalization to that effect. If you see this order, which has been passed and closed out here at page 30, nah? Where is that order?
Page 34.
Page 34. Let us see that order. Without going into the determination whether the work order has been issued, we clarify our interim order dated there that the expression shall not undertake any further process means if the work order was not issued as on quoted, the same shall not be issued, and if issued, it shall not be acted upon.
Yes.
We also clarified that the interim order dated demand shall be in respect of only those tenders. Where is the question? There is only one tender
Yes, that is why we read it
where the petitioner has participated. The petitioner has participated only in one tender.
one tender. So it is to be for all
Do
intended
you have
purpose.
to quote separate tenders for separate vehicles? No.
No,
So therefore, when he quotes, this order seems to be on an assumption which we have in the PWD and I notice inviting tender that there are 6, 7 works which are given in the notice inviting tender of which a person quotes for 2. That's a different, but here it is 9 vehicles or 8 vehicles which
8
is being sought for, of which a person can quote for 1 or maybe quote for 8.
that is why, my lord, what we assumed or what for all intent and purpose, my lord, those instead of tender, it should be read as the bid submitted by the writ petitioner.
So if it is the bid submitted, means the entire thing has been stalled.
No,
Yes.
because he submitted that writ petitioner had submitted his bid in respect of 2 tender.
No,
2 tankers.
that cannot be. Shall not be in respect of only those tenderers where the petitioner has participated.
That is why,
Meaning
my lord,
the petitioner has participated in only one tender was issued, everything was won.
that is why, my lord, when the matter has gone to the division bench, there is an order passed by the division bench which your
Yes, what
lordship
does
will
it say,
find
the division
by
bench?
page 38.
Who has filed this in the division bench?
The other persons were issued anyway.
Condone the delay. Okay, it appears that on the same day on FEA, the ONC has issued the letter of FEA to 5 bidders
My lord,
during the
it appears that on the same day, 4/10, to the respondent ONGC has issued NOA to 5 bidders, including the present writ petitioner. The respondent number 5, writ petitioner filed an interlocutory application being so and so before the writ court with a prayer to issue direction for cancellation of the NOA issued by the respondent to different bidders, but that NOA were never cancelled. It is also to be noted that in the said interlocutory application as well as the pending writ petition, the applicants were not implemented as party respondents and the same till aforesaid writ petition was allowed. So and so, so and so. No. The fact, now the last but one word, the fact remains that NOA were issued in favor of the applicants on 5/10 pursuant to the tender notice issued by the respondent. The respondent number 5 writ petitioner was aware of the said fact and also brought to the said fact to the notice of the writ court by moving an interlocutory application. However, he had not made the applicants as party respondents in the aforesaid writ petition. The learned single judge set aside the tendering process by the order dated
So this is pursuant to the order passed by
on 26.
the coordinate bench.
Yes, this is the writ
So
appeal.
this writ appeal is against this order. of 26.
And this honorable division bench allowed those particular bidders to continue with the work.
We deem it appropriate to direct the respondent authorities not to discontinue the notification of award issued in favor of the applicants.
So,
However, the respondents are free to proceed further in pursuance to the fresh tender notice dated so and so in respect of other services except the services already being rendered by the applicant. Now, these applicants are different.
yes, my lord.
So the interference so made by the learned division bench is only in favoring those applicants,
Yes, applicants because they
and
were,
the petitioner was not there.
because petitioner, along with those applicants, the petitioner was also awarded the NOA. But since he failed to comply with the supply,
But how do you read it? The order categorically says that in the facts and circumstances, we deem it appropriate to direct the spur not to discontinue the notification of award issued in favor of the applicants.
my lord, that is what I am submitting, my lord. The notification of award was issued to 5 bidders, including the writ petitioner, on 4/10/23. Others continue with the work they supplied within the stipulated time. Only the writ petitioner failed to supply. That is why his NOA was cancelled or terminated. Now the question, had the writ petitioner gone,
But don't you think that the appellate court, the writ appellate court, had only carved out only the benefit, otherwise did not touch the judgment of the learned single judge, except in respect to the 4 applicants,
because
on the ground that they were not made parties?
Because, my lord, these 4 applicants and the writ petitioner stood in the same footing as on 4/10/23. All were issued NOA. These 4.
But that was not saved by the division bench. The division bench did not save the writ petitioner's thing.
Because the,
Did not give you the liberty in respect to the writ petitioner hearing.
my lord, that division bench could not save the writ petitioner because by the time the writ petitioner failed to perform his contract and the contract was terminated. Had the writ petitioner continued with the work, then the writ petitioner would have been in the same footing as that of the applicant. So he would have also continued. Here it is a case, the writ petitioner, because of his own fault, could not go ahead with the contract. Others, lordship may have a look at the page 9 of our IA. We have stated at paragraph 7, who are the persons who were given NOA on 4/10/23. And these persons include the applicant except the writ petitioner, because by that time the writ petitioner's status was that of a terminated contractor. Had the writ petitioner continued with the mobilization or he had gone ahead, then he would have been,
Mr. Chakraborty, no, I think we need to.
my lord will appreciate one thing. As on the date of termination of the contract, there was a valid or subsisting NOA?
So, but it was state.
No, my lord, it
It-
was not state.
It was state.
It was in respect of 2 bids submitted by out of aid. Mamadullah, who is the writ petitioner, submitted his bid in respect of 2 tankers. That is
No,
why,
there is only one tender. But he submitted the bid, maybe for 2 also.
my
But that is not being said. The entire thing was stayed on 4/10. 4/10, then there was an explanation which has been given in the month of November, wherein it says that, okay, if no LOA has been issued, no problem. Thereafter, it is said that if the LOA has been issued, don't go further beyond that. And then it has been further mentioned, it will be in respect to the tender which have been submitted. There is
tenders.
There
What
is
is
only
tender?
one tender.
So,
We have to understand that.
my lord, for all intent and purpose, that tenders means the bids.
No. I will explain.
My lord,
Okay.
let us one,
Mr.
my lord,
Alan Dihingia. No, enough. Alan Dihingia, the learned counsel appearing on behalf of the petitioner.
lordship,
And Mr. S. Chakraborty, the learned counsel who appears on behalf of the ONC. The petitioner herein is aggrieved by the action on the part of the respondent authorities in terminating. I'm not interfering with the termination. I'm only interfering with the blacklist. Termination.
for that, my lord, if your lordship give me
No
2
more.
minutes time, I will take your lordship to that part of the,
Every minute, 10,000 rupees cost.
my lord,
1,000.
as a consequence of termination,
There's
if your
nothing-
lordship upholds the termination to be
No,
put, then as a
no, no.
consequence of termination, lordship will definitely examine that clause 18.6.
Have at sale. By the present petition, the petitioner herein have at sale the communication dated 16/1/2024, whereby the contract with the petitioner was terminated. Semicolon. the communication dated 22/8/2024, putting the petitioner on holiday, thereby debarring the petitioner from taking part in any ongoing or future contract with the respondent ONGC. As well as seeking further consequential directions. Seeking further consequential directions. The case of the petitioner herein, as would appear from the materials on record, is that the respondent number, yes, take your seat. Respondent number 2 had issued a invitation to bid for hiring of 9 KL water tanker service for Assam asset for a period of 3 years through its e-procurement site https://etender.ongc.co under a 2-bid system. It is relevant to take note of that in the invitation to bid, the period of the sale of the bidding document was mentioned from 12/2/2023, bracket 10 hours, to 6/3/2023, bracket up to 13.59 hours. The date and time of submission of the bid in the e-portal of ONGC was on or before 14 hours, bracket IST, of 6/3/2023. The technical bid was to be opened on 6/3/2023 at 1500 hours. And the last date for submission of the physical documents was up to 1400 hours of 6/3/2023. The said bid document contained various parts in the form of annexure Roman 1, Roman 2, Roman 3, Roman 4, Roman 4A, Roman 5, and Roman 6. Where is that clause that if there is a L1, more than 2 L1 bidders, then it will be given to that? Where is that clause?
My lord, your lordship will get it in the bid evaluation criteria, my lord. Page 180. T7, in case same rate is received from different bidders, ONGC will evaluate the rank the bids on the basis of following criteria for particular type of water tankers in the following order of preference: vintage of the offer, minimum mobilization period, time quoted.
Annexure Roman 4 to the invitation to the bid pertain to bid evaluation criteria. In terms with clause B.1.4, there were three categories of water tankers to be offered. For category 1 pertain to those water tankers owned and registered in the name of the bidder, that is the existing water tanker. Category 2 were in respect to water tankers which are to be purchased new. And category 3 are those water tankers which are under lease agreement from the registered owners. Clause C.7 is a relevant clause for the purpose of the present proceeding. Inasmuch as the said clause stipulates when same rate is received from different bidders, in terms with the said clause, the ONGC will evaluate and rank the bids on the basis of three criteria for that particular type of water tankers. The first criteria is the vintage of the offered water tanker. That is, the latest vintage would be given preference. The second criteria pertains to the minimum mobilization time quoted for the offered water tanker. It is further mentioned, categorically mentioned, in the second criteria, that if the bidder fails to mobilize the water tanker within the quoted mobilization date, what is that NOA?
Notification of award.
The notification of award will stand automatically cancelled. And in such cases, the next qualified bidder, as per the originally evaluated order of ranking, shall be considered for issuance of the letter of intent / notification of award. Notification of award লেয়ার ব্র্যাকেটত NOA, letter of intent LOI. The third criteria was in respect to the experience of the bidder. Clause C.7 being relevant is reproduced herein under page 180. The materials on record show that this court further finds it pertinent to take note of another very pertinent clause, which has relevance for the purpose of determination of the present dispute. Annexure Roman 4A is in relation to the techno-commercial metrics. In the same document, there's a clause being clause C.2, which is in relation to the bid submission matrix. The said clause C.2 being relevant is reproduced hereinunder, page 200. It is relevant from above quoted clause. It would be seen that the rate so to be quoted. It would be seen that the ONGC had incorporated a viable range thereby stipulating that the basic running rate per kilometer exclusive of applicable GST should not be less than 0.275 into diesel rates declared by IOC for Sibsagar as on the tender open bid, technical bid opening date. In respect to the instant tender, the technical bid opening date would be 6/3/2023. 23. And therefore, it appears that the bidder cannot, bidder's bid would be rejected if it quotes the basic running rate per kilometer exclusive of GST below 0.275 into the diesel rate declared by the IOC for Sibsagar on 6/3/2023. It is further pertinent herein to take note of that one of the bidders, one of the participating bidders, intending bidder, one of the participating, you have participated, na? Your earlier client was participating. One of the participating bidder, namely one Mahmoud Ali, challenged the rejection of his bid on the ground that he had quoted less than what is stipulated in clause C.2 as above quoted. One of the participating had filed a writ petition. None. Mahmoud. Above quoted. The said writ petition was registered and numbered as WPC number 5870/2023. Where is the first order passed? 410.
My lord, page 267, my lord.
This court, upon filing of the said writ petition by Mahmoud Ali by the petitioner in WPC number 5870/2023, passed an order that till 6/10/2023, the respondent IOCL authorities, this is by ONGC or
Yes,
IOCL?
It is, ONGC is the authority.
My lord,
IOCL
it
is
was
the-
my lord, file my lord, I am my lord, it was notified my lord.
The respondent IOCL authority shall not undertake any further process in terms with the price bid opening statement dated 26/9/2023. It appears that the reference made that the respondent the reference made in the interim order, inverted comma, respondent IOCL authorities ought to have been the respondent ONGC authority, as would appear from the very tenure of the order dated 4/10/2023. It has been brought to it is stated at the bar that the said aspect was modified by an order dated 6/10.
Lordship, IA number 3253 of 2023, my lord. Order dated 10/11/2023.
The said aspect have been subsequently corrected by an order dated 10/11/2023 in IA number yeah in this is not IA, was subsequently corrected by the order dated 10/11/2023. Another interesting development took place on 10/11/2023 in the order dated 10/11/2023, whereby this court observed that without going into the determination as to whether a work order is issued, was issued, whether a work order was issued, the learned coordinate bench clarified the expression shall not undertake any further process. Expression shall not undertake any further process, inverted comma, to mean that if the work order was not issued as on 4/10/2023, the same shall not be issued, and if issued, it shall not be acted upon. It will further clarify that the interim order dated 4/10/2023 shall be in respect of only those tenders where the petitioner had participated. Subparagraph. At this stage, before proceeding further, this court finds it very pertinent to make an observation that the learned counsel appearing on behalf of the respondent ONGC, while drawing the attention of this court to the order dated 10/11/2023, submitted that the clarification so given that the interim order dated 4/10/2023 shall be in respect of only those tenders where the petitioner has participated would mean that the interim order dated 4/10/2023 shall be applicable in respect to those bids where the petitioner had participated.
Submitted. Bids submitted.
If the bids participated,
Submitted, my lord. Because he submitted two bids. That
he has
is
participated in the two
one
bids.
tender. Participated in one tender, submitted two bids.
Can you submit two bids?
Yes, for two different vehicles.
Where is it? Show me in the tender that you can submit two bids.
Yes, this is at page 60 of our additional affidavit.
No, where is it in the tender document? Where? No, it should be read as the petitioner had submitted that the interim order dated 4/10/2023 shall be in respect to only those bids which the petitioner had submitted. Because in the opinion of the court, the said submission does not appear to be proper. It appears to be misconceived. Inasmuch as there was only one tender which was issued. And the petitioner in WPC number 5870/2023 has participated in respect to the said tender and thereby offering two vehicles. Now, moving forward, next paragraph. Moving forward, it is very pertinent to observe that the petitioner in the present proceedings, along with four other bidders, four other bidders, were issued letter of intent, letter of acceptance, LOA,
NOA, notification of award.
NOA,
NOA.
were issued notification of award on 4/10/2023.
The list your lordship will find in our IA. paragraph 7.
You have issued, I'll take it. Now, if this court duly takes note of the order dated 10/11/2023, and the notification of award dated 4/10/2023, which have been issued in favor of the petitioner as well as the four other bidders, the only conclusion that can be drawn that if the notification of award have been issued, it shall not be acted upon. And petitioner quoted for how many vehicles?
Petitioner, two vehicle, my lord, one, yes, sir.
Your earlier petitioner, two
Two
vehicles,
vehicle
and the present,
Present also, my lord, two vehicle.
Two vehicle, but given for one.
it's okay. It is also very pertinent to observe that there was no further clarification sought for in respect to the order dated 10/11/2023 by either of the parties in WPC number 5870/2023. But one aspect is very clear, that the petitioner in WPC number 5870/2023 submitted the bid for two vehicles, two tankers, and the petitioner herein have also submitted the bid for two tankers, and notice of award was issued only in respect to one tanker. So, it further appears from the materials on record that pursuant to the order dated 10/11/2023, as the petitioner. No. Before further proceeding, it is also very pertinent to observe that there were how many L1 bidders, how many L1 bidders were there?
Total 8. My lord, participated.
Till number 9.
Total 7, L1 7,
L1.
L1 was 9.
7.
It is
Writ
very
petitioner
pertinent to
along with
observe.
7 other bidders.
No. Before further proceedings, this court finds it very pertinent to observe that in the tender process which was initiated in respect to calling for bids for 8 tankers, there were 9 bidders who quoted the L1 bid, who had quoted
In fact, my lord, in our IA, at
who
paragraph
had quoted the same rate. How many? 9.
8.
8.
8.
8 bidders who have quoted the same rate. And the petitioner herein, having quoted the rate, same rate, and had provided that he would be in a position to mobilize the tanker within 59 days, the petitioner was issued the notice of award on 4/10/2023. Full stop. The record further reveals that the petitioner within 59 days could not mobilize the tanker in question. Resultantly, on 1/12/2023,
No, my lord. On 16/1/24, 1/12 he sought for extension of time, which was rejected, and on 16/1/24,
resultantly, on
1/24, page 270 of the writ petition.
16/1/2024,
No, was terminated.
the contract was terminated. Then the contract, no, the notice of award was terminated. Which is the subject matter of the present writ petition. The record further reveals that pursuant thereto, on 22/8, the record further reveals that on 26/2024, the respondent no, 26/2024, the writ petition which was filed, being WPC number 5870/2023, was allowed. Only inter alia, that the disqualification of the petitioner in the said writ petition was not proper, and directions were issued for a fresh tender notice for the Sibsagar district thereby incorporating in the tender notice a method to enable the tenderers to get to know the standard rate of HSD for Sibsagar district for each day. Full stop. This court further directed by the order dated 26/2024 that not to issue any notification of award to any of the bidders in respect to the NIT number R16KC230303 insofar as it relates to the Sibsagar district. Paragraph number 12 of the order passed by the learned coordinate bench on 26/2024, being relevant, is reproduced hereunder. Pursuant thereto, on 22/8/2024, the petitioner was issued a show cause notice as to why the petitioner should not be put on holiday. And further, the petitioner was provisionally put on the holiday list. The resultant effect of the said communication dated, said show cause notice dated 22/8/2024 is that the petitioner herein have not been permitted to participate in all notice inviting tenders issued by the respondent ONGC. It is under such circumstances the petitioner has filed the incident writ petition. And this court, by an order dated 2/9/2024, suspended the notice dated 22/8/2024 and further passed direction that the petitioner be permitted to participate in the fresh tender process or any new tender process, which shall, however, be subject to the outcome of the writ petition. The record further reveals that the respondents, ONGC, had filed an interlocutory application being IAC 3297/2024, justifying its action of termination of the petitioner, as well as further putting the petitioner further issuance of the show cause notice dated 22/8/2024 and provisionally putting the petitioner in the holiday list. Mr. S. Sokorbuti, the learned counsel appearing on behalf of the ONGC, submits that though no affidavit in opposition has been filed, but the document, but the interlocutory applications of the contents of the interlocutory application be treated as the affidavit in opposition for the respondent authorities. Next.
Interlocutory application and the additional affidavit filed in the interlocutory.
As well as the additional affidavit filed in the
Aye.
interlocutory application. First. In the backdrop of the above, let this court now take note of the submissions so made on behalf of the parties. Mr. L.N. Dehania, the learned counsel appearing on behalf of the petitioner, submitted that as Mr. K. Chaudhary, the learned senior counsel, is not available, he is not in a position to make arguments. It is under such circumstances, this court heard the learned counsel appearing on behalf of the respondent ONGC. Mr. S. Sokobuti, the learned counsel appearing on behalf of the petition respondent ONGC, submitted that the petitioner herein have been the petitioner, the termination of the petitioner is in terms with clause C.7 of the bid evaluation criteria, Annexure 4, Roman 4, to the invitation to the bid. Inasmuch as the petitioner hearing, was inasmuch as although there were 8 bidders, the petitioner was issued the notification of award on the ground that the petitioner had submitted in his bid that he would be in a position to mobilize within 59 days. The petitioner having not mobilized, within the period of 59 days, by virtue of clause C.7 Roman 2, the petitioner's notification of award stands automatically cancelled. The learned counsel appearing on behalf of the respondent ONGC further submitted that clause C.7 Roman 2 have not been assailed by the petitioner, and under such circumstances does not lie in the mouth of the petitioner to assail the termination as on 16/1/2024. The learned counsel further submitted that, which is the blacklisting,
My lord, at page 123, as a consequence of termination, 18.6. Page 123.
the learned counsel for the respondent further submitted
18.6, 2 will be relevant in this
that
case.
in case that the what is this?
My lord. 18.6. This is the general
0.6
condition.
I understand, but what is that document?
This is is a part of the bid document, which is also the general conditions of contract
18.6 of what?
of the bid.
STC.
GCC. This is part of GCC. And the petitioner,
The learned counsel appearing on behalf of the respondents, ONGC further submitted that in terms with clause 18.6 of the GCC, the consequences of termination have been spelled out. the tender conditions permit the respondent ONGC to make inquiry and pending inquiry, make inquiry as to whether the bidder is to be put in the holiday list, and pending inquiry, ONGC has the power to put the bidder on the holiday list. It is further mentioned, the Learned Council for the Respondent ONGC further mentioned that the ONGC shall, that in terms with clause 18.6 Roman 2, it is the mandate that the ONGC shall neither issue any tender inquiry to the defaulting contractor, nor shall consider their offer in any ongoing tender. And therefore, the stay order which have been passed by this court is contrary to the terms of the bidding documents, which holds the field between the petitioner as well as the respondent, holding the field in between the petitioner and the respondent authorities. Anything more? Oh, also, the Learned Council for the petitioner, for the respondent ONGC further submitted that the setting aside of the tender by the order dated 26/2024 in WPC number 5780/2023, 23, na? Would have no impact on the present dispute, in as much as the order dated 26/2024 was passed prior to the termination of the petition.
The termination order was passed earlier. On
Was passed, 2026 was passed subsequent to the termination of the petition.
And it was not challenged during all these days. From 16/1/24 to this date, they had not challenged. It is only after this order has come, they have created a.
He, however, submitted that the subsequent actions so taken for blacklisting the petitioner, the putting the petitioner on holiday list, is subsequent to the order dated 26/2020.
As a consequence of termination.
Determination and analysis.
You may also observe that order of the division bench wherein the similarly is other persons who were issued NOA were allowed to continue.
Let me do something. As the counsel for the petitioner was, as the counsel appearing on behalf of the petitioner did not argue, this court have perused the materials on record as well as the pleadings. First, as the counsel appearing on behalf of the petitioner did not argue, this court would take for this court, for the interest of justice, or deal with the contention of the petitioner on the basis of the pleadings already on record.
Well, there is a delay part, my lord. My lord, clause 19C, my lord, there is a delay of mobilization, my lord. Also mentioned in the NIT, my lord. Page, my lord, 124.
Or the guy is unable to deploy or commence the survey within the period specified in subclause A. Now, this won't come, na?
Petitioner already submitted, my lord, his security money, my lord.
No, this won't come here in the picture because of the fact that this is for 90 days. You did not get it as a highest bidder. So next time, Mr. Dihingia, don't make this type of submission before this about senior. See there?
Yes.
And Mr. K.N. Chaudhary has not appeared because I will tell him cartelization. Other courts have more better. They don't say like, I will tell cartel. Why both the petitioners are same? Same counsel, everything same. Oh dear, hey, I got the LN Dihingia submitted. I'll put your submission, not Mr. K.N. Chaudhary. Mr. L.N. Dihingia, the learned counsel appearing on behalf of the petition, submitted that when there was a stay operating in respect to the notification of the award dated 4/10/2023, so issued in favor of the petitioner along with other bidders. And there was further specification, further clarification by the order dated 10/11/2023 that there shall be that the notification of the award shall not be acted upon, comma. The action on the part of the respondents to insist upon the petitioner to carry out the mobilization amounts to willful and deliberate violation of the orders passed by this court. The learned counsel appearing on behalf of the petitioner submitted that though the petitioner was not a party to the said proceedings, but the respondent authorities very well knew about the order dated 4/10/2023 as well as the subsequent order dated 10/11/2023. The learned counsel appearing on behalf of the petitioner further submitted that by the order dated 26/2024, this court had categorically held that the entire tender process was vitiated in view of clause C.2 of Annexure Roman 4A. And as such, when the very tender process has been vitiated, the action on the part of the respondent authorities, knowing it very well, to proceed and issue the notice dated 22/8/2024 is not only a case of deliberate, willful and deliberate violation of the order, willful and deliberate disregard to the orders passed by this court, but also clearly shows the malafide, the perversity as well as the malafide intentions on the part of the respondent ONGC. Anything else?
One more, my lord,
Yes.
in page 180, my lord, clause C.7, my lord. My lord, here, my lord, is specific mention, my lord, in such case, next qualified bidder as per originally evaluated order of ranking shall be considered to issue for LOI annulment. Since, my lord, the petitioners not, my lord, submitted within, my lord, stipulated time, my lord. Since there was, my lord, 11 numbers of L1 bidder, my lord. If, my lord, petitioner not, my lord, within the stipulated time.
He's saying 8.
No, my lord, I have filed, my lord, in my additional affidavit, my lord.
This is what
I have annexed, my lord, the price bid note, my lord, page 72.
total 40
No, how
bidders.
does it apply?
My lord.
How does it help you?
Because my lord, if my lord petitioners, but since there is a my lord, other L1 bidder, my lord, they have not, my lord, award to the other contractors, my lord.
They will do it. So how does it matter?
And even my lord, one more my submission, my lord, this after the my lord, past my lord in 5870/2023, my lord, in WPC number, then my lord, that since my lord, the tender was set aside, my lord, and repetition was allowed, and subsequent my lord, ONGC my lord issued my lord, the subsequent tender, my lord, withdrawing them the particular clause, my lord, C.2, my lord, and against my lord, 8 numbers of tender, my lord. My lord, my prayer submission is that my lord, already my lord.
So, Mr. Dingya,
Then-
then don't intermix between two of your different clients. C2 was offensive for Mahmoud Ali,
Lordship.
not for this Borguhai. This is
Yes.
Borguhai,
Borgohain.
Borgo.
not for Borguhai.
Lordship.
So C2 is only offensive for Mahmoud Ali. So whenever you do a case for Mahmoud Ali again, make that submission. I think this submission will be enough to take care of them. I may also, the learned counsel therefore submitted that such actions on the part of the respondent authorities of blacklisting the petitioner or putting the petitioner on the holiday list amounts to violation of not only amounts to violation of Article 14 of the Constitution, but also violates the mandate of Article 19(1)(g, read with Article 21 of the Constitution. No. Let me come back. Court अपनी लिखी रिवर the analysis. Analysis and determination. The materials on record as discussed herein above as well as the respective submissions made by the learned counsels appearing on behalf of the party would show that the tender so issued by the respondent ONGC for hiring 8 numbers of water tankers services for a period of 3 years was interfered with by the learned coordinate bench in WPC number 5780/2023 by the order dated 26/2024. The facts that the petitioner herein was awarded the notification of award on 4/10/2023 is not disputed. The materials on record also show that this court by an order on the same day, that is on 4/10/2023, have directed the respondent ONGC not to further undertake any further process. And this aspect of the matter was further clarified by an order dated 10/11/2023 in WPC number 5780/2024 to mean that if the work order was not issued as on 4/10/2023, the same shall not be issued, and if issued, it shall not be acted upon. The order dated 10/11/2023 therefore makes it very clear that if the award has been issued, notification of award have been issued, to any of the bidders, the same shall not be acted upon. The learned counsel appearing on behalf of the respondent, as above noted, as already noted in the previous segments of the instant judgment, had submitted that the said interim order dated 4/10/2023 shall only apply insofar as the tenders which the petitioner had submitted. However, this court is of the opinion that the said submission appears to be misconceived, taking into account that the order dated, taking into account that the petitioner in WPC number 5780/2023 submitted bid for 2 tankers. The order dated 10/11/2023 was passed in, the order so passed on 4/10/2023 as well as on 10/11/2023. In WPC number 5780/2023 was in respect to one single tender. There is no further clarification sought for by the respondent ONGC in WPC number 5780/2023 as to what would be the implication of the clarification given in the last line of given that the said interim order dated 4/10/2023 shall only be in respect of shall be only in respect to those tenders where the petitioner had participated. Under such circumstances, it has to be understood that the order dated 4/10/2023 was applicable in respect to all the bidder, all the bids was applicable in respect to the tender in question, and more particularly in respect to 2 tankers which the petitioner had submitted. There is no distinction being brought in, nothing has been brought on record to distinguish that the bids so submitted by the petitioner herein were not in respect to those tankers which the petitioner in WPC number 5780/2023 had submitted. Under such circumstances, in the opinion of this court, by the order dated 4/10/2023, there was a complete stay in respect to performance of the work pertaining to the notification of award dated 4/10/2023 issued in favor of the petitioner. Next. It further appears from the records that the petitioner was not a party in WPC number 5780/2023.
5870.
You were party.
No, my lord. No, case number, my lord, 5870.
I'm saying that petitioner was not a party. He was not a party in WPC number 5780/2023. And as such, the petitioner may not have knowledge about the stay order dated 4/10/2023 or the clarification given on 10/11/2023. However, the respondent authority ONGC was very much aware about the order which had been passed on 4/10/2023 as well as the subsequent clarification on 10/11/2023 not to go ahead with the notification of awards which was issued on 4/10/2023 in respect to the 2 tankers which the petitioner in WPC number 5780/2023 have submitted the bid. In spite of that, the respondent authorities terminated the bid of, terminated the contract of the petitioner on 16/1/2024 on the ground of non-compliance with the proviso to clause C.7 Roman 2 in terms with clause C.7 Roman 2. So this court finds it very difficult to appreciate that, finds it very difficult to accept that clause, that the conditions so mentioned in clause C.7 Roman 2 would have been applicable insofar as the petitioner, when there was a stay being granted by this court on 4/10/2023 and subsequently clarified on 10/11/2023. The court further finds it very pertinent to observe that by the order dated 26/2024, the learned coordinate bench of this court had set aside, had nullified the entire, all the notifications of awards. So had nullified the entire tender process in view of the ambiguity in clause C.2 of Annexure Roman 4A, and further directed that there shall be no issuance of the notification of awards. The record further reveals that the respondent ONGC had duly accepted the said judgment passed by the learned coordinate bench in WPC number 5780/2023, inasmuch as no appeal thereagainst was filed. At this stage, this court finds it very pertinent to take note of another relevant aspect of the matter, which is there in the interlocutory application so filed by the respondent ONGC. That is, that 4 of the bidders who were issued the notification of award have filed an appeal against the order dated 26/2024 passed in WPC number 5780/2024. The said appeal was filed with a delay of 47 days, and an interlocutory application was filed for condoning the delay. At the stage of condoning the delay, the learned division bench of this court while condoning the delay only said the notification of awards so issued to 4 of the bidders. This aspect of the matter would be apparent from the order dated 26/9/2024. And the relevant portion of the said order is reproduced herein under page 40, technically. This court also finds it very pertinent herein to observe that this order, so passed by the learned division bench of this court, is subsequent to the action taken by the respondent authorities, respondent ONGC, of issuance of the show cause notice dated 22/8/2024. Therefore, on the basis of the said order, the respondent ONGC cannot justify their action in respect to the issuance of the notice communication dated 22/8/2024. In the backdrop of the above, let this court now take note of as to whether the respondent ONGC was justified in issuance of the notice dated 22/8/2024, as well as further putting the petitioner provisionally in the holiday list. First, it is the opinion of this court that by virtue of the orders dated 4/10/2023 and the clarification dated 10/11/2023, it cannot be said that the petitioner had not complied in terms which the condition mentioned in clause C.7 Roman 2, inasmuch as there was a bar on the bar issued, inasmuch as there was a injunction issued by this court not to proceed with the notification of award so issued. That was an injunction, right? There was a prohibition on the part of this court not to further proceed with the notification of award dated 4/10/2023. Under such circumstances, the question of termination of the petitioner, as above noted, did not arise. If there was no termination of the award, if the termination was not permissible, the question of applying clause 18.6 of the general conditions of the contract did not also arise. This goes further, finds it pertinent to observe that by the order dated 26/2024, passed in WPC number 5780/2023, the learned coordinate bench of this court nullified the entire tender process. However, the learned division bench of this court, as above noted, have only saved 4 of the notification of awards issued to those applicants in IA number. In IA number
I number, my lord, 2803 of 2000.
2803/2024. Therefore, in respect to the remaining notification of award so have been issued by the respondent ONGC on 4/10/2023, loses its existence on the basis of the order dated 26/2024, passed in WPC number 5780/2023. The resultant effect is that the respondent of ONGC could not have made the issuance of the notification of award in favor of the petitioner as a ground or the basis for the purpose of initiating any action under clause 18.6 of the general conditions of the contract, in as much as it would be permitting the respondent ONGC to take steps on a non-existent fact. It is a trite principle of law that any action taken on a non-existent fact would come within the ambit of malice in law. See SR Venkataraman versus so-and-so 1979 2 SCC 498. Bracket. Accordingly, the instant petition therefore stands disposed of with the following observations and directions. Number one, this court is not inclined to interfere with the order of termination dated 16/1/2024 on the ground that by virtue of the order dated 26/2024 passed in WPC number 5780/2023, the notification of the award dated 4/10/2023 was nullified and had lost existence. Number the action on the part of the respondent authorities to terminate by the communication dated 16/1/2024 is unfair and unjust, and further is unfair and unjust, taking into account that the petitioner herein would not have been asked to perform the part of his contract on the basis of the notification of award dated 4/10/2023. In view of the order dated 4/10/2023 and subsequent clarification dated 10/11/2023 in WPC number 5780/2023. Number three, the action on the part of the respondent authorities for issuance of the communication dated 22/8/2024, as well as provisionally putting the petitioner in the holiday list, amounts to malice in law and accordingly interfered with. In the factual scenario, this court is not inclined to impose.
Different.
Only my lord that earlier WBC number
Ah.
5870 of 2023, my lord, dictated my lord 5780.
5780.
5870 actual case number.
He will do it.
Different. See, I was on legs in court number 7.
I put Mr.
No, it's okay.
But Mr. Chaudhary, encourage your juniors to argue.
No, yes, correct. No, I encourage them, my lord. They do not gather courage in that. I always ask them. It's high time they do it also.
Item 9.
Oh, this one. Have you filed an additional affidavit?
I have filed an additional affidavit. My lord, I have clarified the matter.
What is there?
My lord, your lordship may kindly see. This, your lordship will find it at page 153.
So what is your stand? The Silchar Municipal Board in a meeting Health of the annual budget of Iman taking format. Yes, what is this?
Lordship may see the annexures, my lord, these are very important,
Lecture,
especially annexure 1159.
self-assessment,
No, before that, my lord.
160,
159, my lord. This,
159.
yes, earlier it was termed as betterment fees, then it was converted to tap rate charge. The per tap, my lord, tap means the water tap.
So you are here now therefore imposing a tap rate charges,
Yes,
not water tax.
no, not water tax. My lord, your lordship, earlier on the last occasion, in 1790 relates to the property tax.
No, water
And-
tax.
Beg your pardon.
79.
79D, my lord, of the Assam Municipal Act.
Mr. B. Gogoi, yesterday there was a direction for disposing of a matter. I said that, okay, I'll dispose it off within 6 months to pay 81 lakhs. That was some SDRF. Remember? Yesterday you appeared in one matter. Yes. Non-payment. But there the issue was on a different perspective. While looking into the file, while getting that order, I could see that initially there was a particular road directed to be made by the deputy commissioner, bringing it within the ambit of 50, section 50 of the disaster management act. Now, initially they did the work out there, and there's no quarrel that they didn't do the work. The deputy commissioner also forwarded that amount, that 81.63 lakhs is required to be paid. Then it was then put to the SEC. SEC gives an opinion that you see it doesn't falls in the SDRF as well as also under section 50, but directed the PWD to arrange its finances from its finances and pay.
Along with the revenue department.
No, to PWD.
PWD,
Has been directed to arrange from its finances and make the payment. So that is the direction which has been given. Thereafter, you file an affidavit, the PWD files an affidavit that yes, we have received. But there's no indication anything, because what has been recorded yesterday, while you say that, okay, 81 lender is admitted. But the direction has to be paid to the PWD to make the payment, because in view of the direction in the SEC.
yeah, in fact, the minute standard.
Minute says that the PWD has to make. So the directions will be in that regard.
Yeah.
To make the.
Then,
Huh?
their handling is there for the revenue department.
Day ending was there for even you were there for that. So you were paying for others. So they have only put it in the normal thing that Mr. B. Gogoi submits that thing. But I think we should make it more detailed because there are 5 affidavits filed in that regard. First,
There, and then the minute. Where this particular-
I've seen it. First, it was been filed by the respond number 2. An additional affidavit filed by respond number 2, then another affidavit has been filed by. So I'll make that order in that manner.
My lord, your lordship may see 79D of Assam Municipal Act.
79B. Methods of calculation of carpet area for consumption.
D for that, rate of tax.
Hmm.
Tax shall be assessed on the basis of annual rental value at the following rates. Now, these are the rates given. And water tax subject to the provision of section 68 and 71 of this act at the rate of 2% annual rental value other than the user's charge. Then, my lord, your lordship may see 79F.
Hmm.
determination of taxes. The rate of taxes determined in accordance with the provision of this act shall be published by the respective municipal board town committee by issuing a public notice within a period of 3 months from the date of coming into force of the Assam Municipal Amendment Act 2012. These determinations shall remain valid for a period of 5 years. At the expiration of 5 years, at the expiration of every 5 years, new determination of rate of taxes shall take place. And so now this is in regard to the property tax matter. And your lordship will find the next page,
79F also says about all taxes.
tax, water tax, but
What-
we are not taking water tax. Well,
What
it's
are you
a,
charging?
it's a charges, my lord, is a kind of quid pro quo, my lord. Because the
So
benefit.
where is your quid pro quo?
Yes, because it's under a scheme. My lord, your lordship will find under Municipal Act Section 266, the government has made scheme, 3 kind of scheme. One is Amrut, this by the state government. Another is Sewerage Board. The another is, my lord, there is 3 I have stated in my petition. These are the schemes we are following, my lord, is financed by the state government. Your lordship will find at 156, paragraph 5. The state government sanctions scheme like Amrut, then PHE and Sewerage Board for water supply to the consumers in terms of section 266 of the Assam Municipal Act. Now under that
So
scheme,
as of now, you don't have water tax.
no,
You have tap rate charges.
tap rate charges,
So there is no water tax.
no.
So therefore you say, and what is the quid pro quo you are showing?
With to go, my lord, under a scheme, we are providing them some benefit like
No.
drinking water.
I think the quid pro quo means how much you have taken, you have to explain. Where is your explanation? That is why I said, saying a fee is a very difficult thing.
No, my
As
lord,
per the settled principles of law, a fee is, there has to be a quid pro quo.
yes.
Now, if there is a quid pro quo, you merely saying that we are not charging water tax, it's okay. Then very well. You are not, this is your statutory right to do so.
Yes, yes.
But you have not chosen to take, it. But you are now going to take a fee.
Fee.
If it is a fee, then you have to give. What is the amount you have received and how you are spending it? Where is it?
Well, one thing I can tell your lordships, if we take water tax, the charge will be very, very high. Not will be possible for the consumers to pay that. Because the calculation, as your lordship has seen, the 79D, it is on the annual rental of the premises. And
Yes.
it will be too high.
Why?
Because the charge will, if it is calculated in that manner, per consumer, it will be very heavy and
You have a statutory power to do so.
we can do that.
You should do that.
Ultimately, what will happen?
But,
This will not-
but the fact is, have you made those assessments?
Those assessment.
You have not.
No, we haven't done it.
So you are still holding the same annual rental value.
But then we are not charging the fees, we are not charging on that basis.
No. If the state government is providing certain benefits
Yes.
to you, means the state government is transferring some benefits to you. Because otherwise these are municipal bodies.
Yes.
So the municipal bodies works on their own. They have their own identity.
Yes.
That is independent of the state. So the state is giving you certain grants in the form of certain schemes or
Yes.
certain aspects. The state is not claiming any amount from you.
No, state is not.
State is not. So these facilities which are being given, this is for the end user, is for the people out there,
Yes.
end user. Now out there, you are therefore saying that we are giving up this water tax and now we are having a water tap which is a fee. Very well. Betterment fee for what? The state government has provided the details. What is the betterment fee for? It cannot be a betterment fee. You already have the thing which has been given by the state. Means for the purpose of running it must be a fee. So if that is for, you have to give more details.
Look, for this scheme, as such, no fund is coming from the state. Sometimes they allow certain fund and we are utilizing that. but then your lordship will find deficit is tremendous. Your lordship expenditure is
Obviously, why, therefore, you should exercise your statutory right.
What will happen in this case, my lord, I am showing an example. Our income is 2 crores something, and the expenditure is 15 crores and odd. Now, that is the position, my lord, and even the employees, they are not getting salaries for 6 months because of the lack of fund. And there is one case also, my lord, one order is
No,
passed.
Mr. Doctor, I have no quarrel. You can very well ask them money, ask the state, ask them to, if you want facilities, we are going to give you, but this is the expenses. You can do. If you want to lessen the fund, the burden upon the consumers, you can also do so by asking for the state grants. The grants is also to be given in terms of, if I'm not wrong, there's a provision, I think, in the constitution, there's a
Yes,
provision
yes,
of the
constitution, my lord.
243 or something. What is that? Mr. Chakraborty, constitution provides a 243J or something. Huh?
P and Q possibly, my lord, 243 P and Q.
Ah,
I'm getting
My lord, there is a decision of this honorable court. My lord, your lordship also heard that matter once. My lord, what happened? The finance department is not giving us any fund. Then the certain.
Mr. Doctor, don't say anything about finance department. The finance department, I also know, you also know, it's one of the most difficult departments. They don't give you the fund, it is okay. Now you are, I think these are finance commission.
Yes.
Now you see, kindly see 243Y. This is how it is to be given. Then there is a demand to be made. Demand will be made to be put out the reservation, composition, funds, municipality, 243, constitution here. I think, yeah, power to tax. The legislature of the state has may by law authorize a municipality to levy, collect and appropriate such taxes, duties, tolls and fees in accordance with such procedure and subject to such limits. So this is the power which is being given to by the Assam Municipal Act
Right.
to you. Assign the municipality such taxes and so and so. Then the Finance Commission, kindly see 243Y.
Yes.
The Finance Commission constituted under 243I shall also review the financial position of the municipalities and make recommendation to the governor. The distribution between the state and so, the determination of tax so and so, the grant in aid to the minister from the consolidated fund.
Yes.
So 243 Y8 Roman 3. So these grants in aid, you have to put it out there, the proposals,
Well,
whether they do or not, that
yes,
is
yes.
another aspect. But if you want to provide, obviously you can very well provide, but you have to exercise your statutory power.
Your lordship is very correct, my lord, what your lordship has said.
But you have done so because he says that last was water tax was increased in the year 2020.
No, 21.
21.
21 they have increased, means it is not that you are not taking water tax.
My lord, what happened in kind of this sort of scheme? My lord, when there is a corresponding increase in the raw materials, then the expenditure will rise. Then only to cope up that situation, my lord, and your lordship will find the increase is very, very minimum. 2000, my lord, I have got that.
So that is what, Mr. Doctor, I asked you to put it. Where have you put it in your affidavit?
That which one, my lord, the calculation.
No. You see, the corresponding increase, you are taking a fee. But
Yes.
however, the fee is, you see, you are to now showing it to be a fee. It is not that you are not taking water tax. You are taking water tax.
Yes, yes. It's a,
So, but you are taking a lesser amount of water tax. What you are doing is you are also having some water tap charge,
yes,
which is like a fee.
fee.
So this additional fee which you are being taken in order to breach the gap between the water tax and the recurring expenses for providing the water.
Yes.
This is for breaching it.
Yes.
So you have to mention in your affidavit.
Uh,
That is why I said,
Well,
where have you mentioned that?
If your lordship look at from paragraph, let me just read out. From paragraph 2 onwards, my lord, page 154. That your deponent most respectfully state that respondent number 6, while its office memorandum dated so and so, made alteration of betterment is section 68K of the Assam Municipal Act to be termed as step rate charge. Therefore, respondent number 6 used to charge betterment fee in respect of water facility provided to the
So
consumer.
this must be also based upon contemporary records.
Yes, that in the
Where are
record,
those?
that melody, your lordship will see that annexure at page 159. 159 annexure
No,
1.
159 is of 2014.
Yes.
We are concerned, we are in 2025. His action is challenging in an action in 2024.
He
This is
says,
how.
my lord, enhancement is too much.
No,
But
he
then-
says the enhancement in water tax.
Water tax, water fee, whatever it is, my lord, enhancement he is saying is from 125 to 300. But my lord, under the swearage scheme, in the same area, they are charging 300 and they are not saying nothing.
No, somebody has to come, na?
Now, who are they, these people, my lord? And your lordship will see that almost all the taxpayers are paying. And these people, some are advocate, someone is a businessman. These people has come with your lordship.
Obviously, somebody has to come.
No, but then what is their agenda?
Isn't it one person's right? If affected, he has the power to come. He has the right to come
My
before
lord,
the court.
absolutely, your lordship.
Maybe it's all others may not have the resources to fight a litigation.
My lord,
Or may not.
the area-
300 rupees.
the-
I'm paying 150 rupees. Why should I pay another 300 rupees if I
no,
pay 300?
whatever
rupees?
your lordship is, I respectfully accept that. But the position is what, my lord, the person from where my learned friend has come, top class litigant in the world possibly.
Huh?
And these people, they are the top class litigant. And they have come for what purpose? But all these consumers, they are paying. They have no objection, even they say they were not knowing. Now you know. Have you given any objection?
No,
All
Mr.
these
Doctor, I
people
ask
pay.
you a specific question. Tomorrow, you are a resident of Guwahati. Tomorrow, the GMC comes up out here and says that okay, for water tax we are going to ask you 3,000 rupees.
No.
Or there is an increase in the annual value, the calculation out there. Many of the people would not mind because they don't like to come to the courts. But if somebody comes to the court coming with a genuine demand, genuine ground, can this court say that no, you go away because other people are paying? No, that
Well-
cannot be the reason why.
Your lordship only like to say that whether there is any constitutional or statutory violation in enhancing this rate. That's the only small area where your lordship will go to see that. Now, this has been an enhancement just to cope up the expenditure.
No, you are increasing it from 125 to 300. Very well. Where are your contemporary records that you are increasing for water tap charges?
Those are the things definitely they have, and if your lordship.
That is
What-
what you have to produce. You were submitted out here because there is nothing mentioned in the earlier documents. So you are increasing from here to here must be on the basis of some board meeting or something. That these water tap charges has to be increased. So that without touching on the, in view of section 79(5), as we are already charging the water tax, we cannot increase for till 2026. So we need this particular amount in order to provide the consumers so and so and to breach the gap. This is the amount. So where are your contemporary records to the effect?
That, of course, my lord, if your lordship look at our annexure in the first affidavit, we have shown that, if your lordship kindly see at page
Page
125, my lord. Annexure 5.
Yes.
Now, your lordship will see in the right-hand side, income, number of connection, your lordship will find domestic, 50,822 numbers. Commercial, 178 numbers. The rate of domestic is 125, rate of commercial 200. And the amount may be received in a year, it is total 2 crores 41,60,200. Now the collection, your lordship will find just down below, 75,69,000 and all. As a result, my lord, right hand side, if your lordship look at, the annual expenditure is 2
Difference is
crores
1 crore 38.
2 crores 14 lakhs
No,
65.
no, difference is 1 crore 38.
Yes, deficit. Now, this is our position, my lord.
So therefore you are increasing in the water tap connection is where is their contemporary records? That is why
That-
I'm only asking that.
My lord, that-
Because if you have mentioned it somewhere that you are doing it for water tap charges, very well,
Yes,
we will consider this to be the water tap charges
right.
and look into it. But that has to be mentioned in contemporary records prior to initiating this action. To me, that
That I'll just take the matter.
One more regarding this imposition of betterment fees also. There is a procedure. I'm sure my senior will have the contemporary record where it shows compliance to section 267 of the Assam Municipal Act.
Sam,
Assam Municipal Act 1956. Section 267.
267.
Well, we were earlier on 79F. Now 79F is gone. Now we are on
Before any
267.
scheme or joint scheme or any purpose mentioned in 266 is sanctioned by the state government, they shall be published in the official gazette and locally the general description, any estimate of the cost of carrying it out and it contains a source from which the cost will be met and the amount of.
That is about scheme, my lord.
So since my lord, the scheme is what has been highlighted in the affidavit on the basis of which the fees are being imposed. So the scheme had to be published in the official gazette as well as locally. So I'm sure my lord, in the official, in the contemporary records, the publication must have been there, which perhaps skipped the notice of the residents of the municipal area. So let this honorable court examine that as well. Let
No,
there
no,
be-
no problem for that.
No, it's okay. But first of all, the question is, there should be a contemporary record that they are increasing on the water.
There's a decision by the board. First of all, there is a decision by the board which must be there in the contemporary record. Then the following of the procedure to the extent of
Under
267.
267.
That my lord will observe in the order, my lord, that will.
One thing, my lord, another thing, very ugly thing that what their client used to do. On the last occasion, my lord, they have, my lord, WhatsApp that in such a manner. I have the paper, but I did not bring it to the next occasion. I'll apprise your lordship what they are doing. As the honorable court has heard the matter at length. The municipal council could not say anything. And ultimately, the court is going to pass an order in our favor. My lord, exactly that I'll just produce to your lordship. This thing should not continue in the next occasion. There's a
If it
very
has
ugly
happened,
thing
it is
in the
unfortunate. If it
Silchar,
has
these people.
happened, I'm not aware of it, but if it has
You,
happened, it is
you are
unfortunate.
aware, you are not saying now,
Yes.
your client is doing,
I
and
can
they are
only
all
say-
the learned people, my lord, the senior advocate. And they are doing all these things, my lord. I'll take that WhatsApp.
No, but Mr. Yeah, kindly share the WhatsApp, share in the WhatsApp what has happened on that day. I asked you, you said whatever it is. So it is already there on record. Everybody can
They
look
should
at it.
expose the correct position of the thing. They should not, my lord, do like this. This is not the proper manner to do.
No, Mr. Dato, the thing is like this. People take advantage of many things which are said in the court. No quarrel with that. Because sometimes it goes beyond proportion. What is actually intended and what is done. That is how the world moves. You can't help it.
But then, my lord,
Once you have a live streaming out there, so you are always exposed to what is happening.
it's a thing, what is the happening in a correct way before the court. You expose it, no problem. But then they are not doing that. The other way they are doing. That is, we are going to, in the court is passing an order in our favor. It is in the, my
The
lord.
order, but my order speaks for itself.
No, it is a different, only your lordship
Yeah.
highlighted to file an affidavit, my lord.
No, per contra, Mr. Doctor submitted that the question arises as to whether there was an increase in the water tax or the fee in connection with the supply of so and so. Paving Peru, they have not taken into account. This court has given an opinion to the teacher to apprise this court whether the enhancement is a fee or a tax. Relevant to observe that when it is a fee, there has to be a quid pro quo element, and as such, if it is a fee, the Silchar municipal board shall provide the details of the quid pro. That's it. I made it very clear. In addition to that, this court further gives an opportunity to Silchar to apprise this court by way of an affidavit as to whether the enhancement is considered to be a water tap. The same has been done in terms with so and so, read with so and so.
Well, the printing in the WhatsApp is this, I have no objection, but I'll produce that, my lord, in the next petition to your lordship. And I'm requesting my learned friend to tell them not to do that.
My lord, if it
They're
has
not
been
very
done,
happy.
I'll again say, if it has been done, I'm completely unaware of what communication has taken place between my clients and I'm not sure with whom. But if it has taken place in the manner which my senior is projecting, it's unfortunate. But as your lordship,
Chakravarti, I think you should tell your client one thing.
my lord,
See, this is the thing which will be involving the rights of around 16,000 consumers.
absolutely, absolutely.
And as such, anything say, unless it is finally decided by the court,
Absolutely correct,
will have a very wrong impression.
my lord,
Just for example, tomorrow if I dismiss your
my
petition,
lord.
they may think what is wrong with this court? The court was saying all along this thing and
Yes.
now the court has turned their back on us or have made a somersault of what he was saying. If I allow your petition out there, then the question would be, there will be certain directions being passed because you see, this would have a lot impact of many people. And these are very sensitive.
Absolutely,
When
my
it
lord,
comes,
absolutely.
it becomes difficult because you see, a state doing anything is a state has the police power.
Absolutely.
But the municipal board or the corporation do not have the police power. So they could have a difficulty in maintaining the law and order.
My lord,
The
my
only
lord,
thing is, when a matter is pending, yes, I may make various expression, make various opinions in the court, I can make a submission, many things, but at the end of the day, what is there is the order which is there.
Yes.
Order says that
speaks
he
for
made a submission, but that is not a part of the pleading, neither what he was also. So he said that, let me be given an opportunity to say whether it is water, tax or fee. Now today he has come up with an affidavit saying that it is a water tap charge, which is like a betterment fee. So I'm asking him, therefore, the question is as to whether if it is so, there has to be a decision taken prior to him doing it. So he will be producing the record. But if you give an impression that an impression goes out there that I am asking him to produce the records because the court does not believe, that will have a very nasty thing.
absolutely, absolutely, my lord, that
So-
is not the intent, that
So
is not
finally,
the.
these things, when the matter is there in the court, I think it should be.
I'll convey it, my lord,
Please
I'll
convey
convey this
your-
to my clients.
If anything is happening,
My lord, from my side, only thing that I can, my lord, say with absolute conviction is from my end, it was just the communication of the order as it was. And
Understood.
thereafter, the interpretation part by,
understood, all these things are there, but the thing is how the people think.
my lord, I understand, my lord.
You
The
must be
petitioner-
aware of what happens in the once you say anything in the court and then people take it, there are a lot of equations, political equations. Many equations are there, what happens. Because this may have tomorrow the Silchar Municipal Board is done by just for Congress or BJP, they may have a lot of
I
things.
Yes.
understand.
The opposition may have a various other aspects.
I understand.
So these are things which needs to be taken note of.
And these are the things going on, my lord. These are all political fight. And the commissioner on that night, my lord, called me and sent that particular WhatsApp. And said, what is happening? I said, these are the things done by the people over there. It's nothing new.
Now, these happen, you see, it is not the handiwork, may not be the handiwork of the petition. But there are many people who must be also seeing the thing and getting an order.
Yes.
If I say this word, as I was saying, kindly produce the records for they may give a wrong connotation without going for following the further what I say, why I need. So that if he doesn't say that why I need it, if he's not mentioned, I ask you to produce the records means the court does not believe. They may say so. Can't help it.
I
We are
have
in-
just, I
We are
have
in
just
the
exposed
digital
that.
age,
My lord,
social media and
the people, my lord, definitely, my lord, there in this process now. So it's a caution to them, you should not make any rumor. If it is a fact, it's okay. My lord, I will not make any such complaint. But then these are always going on. And this
It
is
is
very,
something like, it's something what you are asking is like a John Doe injunction, which I have to pass. Okay. Pursuant to the order passed by this court on 29/7/2025, the Silchar Municipal
Correct.
Board
Hello.
had filed an affidavit. From the perusal of the affidavit, it is seen that in order to man the various sanction schemes like Amrut, PHE and Sewage Board for water supply, the Silchar Municipal Board is not enhancing the water charges, water tax, but rather in the name of rather imposing an additional water tap charge, which is a betterment fee in order to meet the expenditure incurred in order to reach the gap between the expenditure tax collected and the expenditure incurred. The affidavit, however, is silent as to when the decision was taken for enhancement of the water tap charges. And taking into account that the Silchar Municipal Board is an authority,
now it's corporation.
an authority
Yes.
under Article 12 of the Constitution, and it is bound to maintain its records. They would be having contemporaneous records as regards the decision taken when to enhance the water tap charges. Mr. D. Chakraborty, the learned counsel appearing on behalf of the petitioner, submitted that if it is in relation to introduction of certain schemes in terms with section 266 of the Assam Municipal Act 1956, there's a compliance required in terms with article section 267. And this aspect can only be seen on the basis of the records so maintained by the Silchar Municipal Board. Accordingly, this court fixes this matter again. How much time?
My lord, at least 2 weeks.
On 11th of September 2025 at 2 p.m. On which day the reports pertaining to steps taken under section 267 of the Assam Municipal Act 1967, as well as the contemporary records as to when the decision was taken for enhancement of the water tap charges, and the reasons for doing so, and the reasons indicated in those records be placed before this court. Mr. S. Dutta, the learned senior counsel, submits that taking into account the sensitivity of the issue, unnecessary let it be. I think nothing will happen.
My lord. Obliged.
Item 18 and 19.
Is this better, my lord? I have to take your list. After my lord to.
Lordship, item 16, Lordship, I want to remind you that the last 3 occasion the petitioner.
Oh, I'll take it. Okay.
Lord, we have to amend the petition, my lord. Lordship may see, my lord, that notification, my lord, on that, my lord, immediately after that, my lord, because 129, it will be much more, my lord, that will be violative, my lord. So they have issued this notification, my lord, later. So we have to amend it, my lord.
Lordship, what I would like to submit is after the queries posed by your lordship, because the affidavit was only limited to the issue of retrospectivity. So I had a meeting with the concerned officials. In fact, I asked them to be present because of the technical nature of the issue, so that there is clarity. There, in fact, what fell from your lordship is what has happened. Because it was 129, there is a power conferred on the appropriate government under section 108. So they can issue binding directions on the AARC to tide over certain. So a series of communications were addressed between the APDCL and the government. It was because of that the government finally issued a direction saying that for domestic and low tension customers, it will remain at 0.7. But for high tension customers, for example, like the petitioner, it will become 1.29. That direction was passed. So that requirement of consultation with the AARC, that was taken care of in that manner. I have those records.
5.2.
Yes, that requirement has been taken care of in that manner. Otherwise, the officer is here. So any,
How do you take care of that? Whether it was not regulated? Because you see,
yes, the month of August, what has happened, that also I asked them that the stand taken in the affidavit is that you have said that it's for 3 months, and August, because from 0.7, there was a hike up to 1.29. They started communicating with the government from the month of August onwards. Because there was no clarity and they could not buy themselves unilaterally hike it to 129 without an order from the ARC. ARC had rejected it or not passed any order. So August also they continued at the previous rate of 0.7.
but that is also needs a clarification in
Yes.
your.
Yes, for 4 months. So it is actually, it has run for 4 months.
So therefore you find again on 110 another one.
Ye-
This is what he's.
Yes,
placing
yes.
it.
That has led to this.
So therefore now they have put it at 0.59.
That is why it has happened.
And in September, now this is again another thing. This is 0.59 they have put in.
And this is not
The
for,
commercial industry is 0.59.
Yes.
Meaning thereby what is this then 1.29?
This this originally 0.59, your lordship will see it comes within the ambit of 25%. But 1.29 doesn't. Till this was issued, because we did not know which way the government was going to decide. Initially, when the government had said that because of their considerations that we cannot allow you to hike it. Then that decision was revisited by the government. Finally, they allowed us to hike the FPPA
But they reduced it from 0.70.
from 0.7 to 1.29.
No, 0.70, then they reduce it to 0.59.
No.
0.59, yes.
Reduction of syllabus. F1 key. F1 key. It was not given effect. He's saying that this was not given effect. He's saying that this was never.
Not given. That is why I'm asking, because the earlier, if I remember that September notification is of 29/9/2023.
Yes.
And therefore another issued on 110.
110.
110, and this is therefore, I think you need to, here again you say for period equal to installments during the period from. Here you are putting, if this document is just looking through. You are maintaining the quarter, you see, for 110/2023 to 31/12.
Yes, if
This is the fourth quarter.
this would have been the fourth quarter.
So what do you want to do?
My lord, that 1.29, that is also, my lord, that exceeds, my lord, that point also, my lord, I have to take.
Otherwise, under 5.16, if at all there is a requirement, if he feels that this is excessive or that this is not in, then a remedy would lie before the ARC because only on the technical aspects.
No, that would be, that I cannot do so now, taking into account that I have already passed an order.
Yes, Your Lordship.
So under such circumstances, I was thinking that as to whether you now see 5.4,
Lordship.
5.4 and 5.3.
Yes, Your Lordship.
Yes, read it. Five point three.
5.3 says the formula will be applied at the end of each quarter by the distribution licensee without making it necessary to go through the regulatory proceedings. The distribution license shall, however, be obligated to provide all relevant information to the Commission simultaneously. In any case where the Commission observes any discrepancies, the same will be adjusted during the next quarter.
So applying that, they can very well approach that appellate authority, 5.16.
Yes, if there has been any
Therefore, I
excessive billing.
dispose it off, holding inter alia that what is your stand.
Yes, Your Lordship.
Now, the ARC should have remanded matter back to the ARC, directing the ARC to look into this aspect of the matter
Yes, Your Lordship.
as to whether there is any discrepancy in terms of 5.1, 5.3,
Yes,
and thereupon to proceed.
yes. In fact, if
Because then what will happen? The fact that they have to pay FPPPA is not in dispute.
not in dispute.
They have to pay. Earlier, they were doing so by, it is inclusive of the basic rate. With the basic rate, FPPA was included. This was done till the month of April 2023.
Yes,
From the month of May 2023, you have started to charge the FPPA separately from the basic.
yes.
And therefore, you have made that particular notification. And therefore, when that notification is, the petitioner's quarrel out here is, you do it for each quarter.
Each quarter.
No, it was not done in per quarter, but the fact is, what does 5.5 say? Quarter of a year or quarter?
5.5 says each control period shall be a quarter year.
Quarter.
That is 3 months.
Quarter year or quarter of a year?
Offer is missing, only quarter year.
So quarter year will be 3 months.
It can be any 3 months, Your Lordship.
Any 3 months.
Yes, Your Lordship.
So what is the problem then?
Yes, that is our
If it is
standard.
a quarter of the year,
Yes,
then it will be that particular year's quarter.
yes, Your Lordship.
So then the interpretation cannot be given to mean that it will be January, February, March.
Yes,
Has to be given as 3 months.
yes.
Every 3 months, there will be a revision.
There can be.
Or there can be a revision, or there has to be a notice. Intimation as regards any revision.
Any revision, yes.
But if you are changing it, then you have to notify.
Yes, we have to note it.
That is.
That is.
So there has to be notify application. So therefore, there appears to be no default on the part if it is taken as 3 months.
Yes. But the fact is that now it has been applied for 4 months before changing it. Whatever be the circumstances, the ARC is,
Petitioner had no issue. to that.
yes. In
But
fact,
that had to be done in view of certain latitude has to be given to the authorities concerned,
Yes.
taking into account. Because the petitioner at the end of the day has to pay.
he has to pay. He has to pay.
There's no quarrel that the FPPA has to be paid.
Has to be paid.
So if the FPPA has to be paid, then it has to be paid. The question is whether there will be a change in the quantum.
A change in the.
I would have understood if the petitioner is a tea industry, it would have been have a different impact
Yes.
compared to a industry which is in the doing the business of a TMT industries, because that runs throughout the year.
Yes.
But if it is a tea industry, a difference of a month here and there would have an impact.
It will have an impact.
Taking into account that if the amount is less, the consumption is less, then in the case thereof, and if you are adding that particular in this year,
Yes.
then it may have an impact.
Because there, the tariff will be determined by the agreement between the APDCL and the industry. They have peak demand and off-peak demand.
So what to do, Mr.
My lord,
Chairman?
here 5.5, my lord, the last sentence, if you allow me, thus FTA surcharge for a quarter shall be charged from the first month of the next quarter.
Yes, first part of the next quarter. So the
Yes.
quarter is what?
Yes,
Quarter is 3 months.
so 3 months.
Quarter is 3 months,
Yes.
but you cannot say it to be January, February, March.
Maybe, my lord, but the notice when issued, it cannot be given retrospective. Because, because we have already, my lord, products were sold, my lord. Why we should, my lord, that is a question, my lord.
The product sold, how does it matter as regards your products being sold out
No,
here?
my lord, it has been given retrospective effect.
Huh.
Notice is given at the end of the month, my lord, and for that month, my lord, they are charging. That is the my.
No, they are, just for example, this document,
Yes,
which you are saying,
Yes.
this is given on 1/10/2023.
yes.
For the period for what?
For the period
Which
from
will be applied for October, November, December.
October, November, December, the electricity consumed in October, my lord. That will be the, my lord.
No, it
No.
cannot be. It has to be 3 months prior to that.
My lord, it cannot be retrospective, my lord. That is my word.
No, then tell me, are you saying that the AGCL,
Yes.
which is the, will know how much fuel will be consumed, what will be the rate of the fuel
Yes.
as on for the month of October, on first date of October? Is it possible?
Quarter, my lord. It is a quarter.
Understood. Let us take the example of 1 month also. Can AGCL, because AGCL informs it to the APDCL then puts it to the consumers.
My lord.
So first the AGCL has to know.
So for a quarter, they have to inform, my lord. Suppose they inform, my lord, January to March, but this is the charge. Then they can put it from April onwards. Because January to March, AGCL will inform that this is the.
This is the amount.
Then from April onwards, they have to charge it.
Yes.
Not March, my lord.
March.
Not of the March.
No. What they have done as per the first notification
Yes.
of the month of May.
Yes, May, last part of the May.
Last part
27th
of the May, which they have done is,
Yes.
they will charge it for the month of May, June and July.
Yes,
During the month of May, May's bill comes in the month of June.
well, bill may come, my lord, but my question is this, well, it can be given effective from June only, not, my lord, May.
Bill will be from the month of June only.
But, my lord, the main question is this, my lord, the consumption of May cannot be taken into consideration, my lord. My humble submission is this.
So, okay. So
Okay.
at what rate should be for the month of May?
May will be whatever earlier it was going on, my lord,
Well, I mean,
because
means for May, it
Yes.
should be what?
whatever in the April, my lord, that will be there.
Huh?
What was there in the April, that will be there.
April it was there. What was there in the month of April?
April, there is no appear separate, my lord. It was inclusive of that. From June only, my lord, they can charge it. From June, my lord, because June up to August, my lord, they have charged it. 3 months, my lord, although they say 3 months, my lord, they have charged up to August. So June, July, August, my lord, they can charge. Not May, my lord. Retrospective, they cannot give it, my lord.
So you mean to say for the
Yes.
month of May,
Yes,
they have to notify prior to that
my lord.
for expenses which is incurred for the month of April.
Yes. Yes. When they come to know, my lord, suppose 3 months, my lord, period, they are informed.
So for the month of May,
Yes.
they have to inform you in the month of April
Yes, last part of April or the month.
as regards what amount have been spent.
Yes.
Show me the bill for the month of May.
Yes, my lord. Bill meant for May is next, my lord.
For the month of May, May
number-
bill.
Page number 32.
No, that is the month of, for the month of May.
Oh.
I'm
What?
saying about what will be the bill
Sure,
in the month
yeah.
of April.
Oh, bill for the month of April.
He
April.
says there,
April.
for the month of
April is there.
what was the bill?
Yeah, I'm just.
You got it in the month of.
Yes.
Yes, sir.
Now, you have a copy of this?
Yes, Your Lordship. This is for the period from 1st April to 30th April. First April to 30th April. So early April, like.
So if we see for this bill and the next bill,
Lordship.
where FPPA has been charged,
Yes, Your Lord.
Mr. Sahiwala, you have given me something which is black in color. You don't see anything.
This-
Can you read what is there in the second page
I'm.
for
Second,
FPPA?
second page, I believe, Your Lordship, is
That's the
number
annex, my
30
lord.
page number 32.
Page number 32. In the application,
Second page is for which period?
May.
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 So here FPPA has been charged.
Charge.
Now, kindly see here,
Yes,
the energy charge
yes.
out here at the first page.
Ah.
You are putting the rate at 7.05, 9.05, 5.05.
My lord.
So where are you adding the FPPA?
In April, it was not there separately. It was inclusive of that.
April,
No,
in
how
pic-
can it be inclusive of that? The rates have been fixed.
when the new tariff order that we have, which is a part of our affidavit, was published by the AARC, the FPPA was sought to be, there was a asterisk which I had taken your lordship to. The table, the tariff table said that it's inclusive of FPPA charges. So because of that, even though we had calculated the FPPA rate for January, February and March, because of this ambiguity in the tariff order, it was deferred it was not charged for the month of April, it was deferred.
So you did not charge
We did not
FPPA.
charge. For the month of April, we did not charge.
Why?
That is what I've been instructed, your lordship.
But you are required to charge as per the
Because
regulation.
APDCL was of the view that if the tariff order itself includes the FPPA within its ambit, then charging another FPPA would amount to double charging
So
them
therefore,
twice.
where is the FPPA in the bill of April?
It is a part of the tariff we assumed for the month of April that it was a part of the tariff at 7.05.
7.05 normal.
Which is the normal tariff.
But this is the same 7.05 which is going on everywhere.
Yes, your lordship. Then it was
Then-
clarified by AERC that no, you are competent to charge the FPPA because if your lordship has the tariff order which was published by AERC, which
Where
is
is
a
that?
part of our affidavit, your lordship.
Here. These are basic tariffs. Additional tariffs have been detailed in the tariff schedule, including existing FPPA.
Yes,
Where is the tariff schedule?
the tariff schedule your lordship will find. Yes, at page number 60 of the affidavit,
16?
60 of our affidavit in opposition. It starts at page number 58,
60.
but the relevant portion is at 60. At the bottom of the page, there is a small asterisk.
Now, understood. These are basic tariffs.
Yes,
Additional TOD tariffs have been detailed in the tariff schedule.
tariff schedule.
Where is that tariff schedule?
The tariff schedule is not, that tariff schedule is not here, lordship.
So here you have put additional tariff schedule? No.
No, these are, so your lordship will see the base tariff itself, this asterisk correlates to the short asterisk at the top of the page, your lordship. It is a part of the decrease in tariff.
Now, where is the, none? This asterisk has to be in respect to here.
Yes, at the top.
Increase, decrease in tariff.
So once we have been
Including existing PPA.
including existing FPPA. So we were under the impression that if the FPPA has been subsumed into the base increase in the tariff, then we cannot charge them twice for the FPPA. That was clarified later by the AERC.
But here the fixed tariff is at 10.
The fixed, this is for some other category, Your Lordship. This is for educational institutions.
No. Kindly come to number down below. HT Industries to above 150 kVA. Option 2.
Yes. The energy charge is 7.0. That is the fixed charge, Your Lordship.
So this is fixed charges is 10.
10
per kilowatt
per kilowatt
per month.
per month.
So why it is 7 it is being taken?
The 7 is the, Your Lordship, energy charge. There, when a electricity bill is drawn, Your Lordship, there are two components. There is the fixed charge and the energy charge. The fixed charge remains the same.
So the demand fixtures remains the same.
Remains the
But
same.
where is the tariff
The tariff, the rate at which it should be charged,
per kilowatt is where?
it's at the rightmost column, Your Lordship, 7.05. The same row, the rightmost column,
7.
7.
No, 7.05.
7.05, Lordship.
Energy charges per kilowatt.
Per
This is
kilowatt.
revised. But this does not have that asterisk column there.
Yes, because the
It
asterisk.
doesn't. Kindly to see. Increase, decrease in tariff, asterisk.
Yes, that is precisely why the AERC later on clarified that APDCL is not prevented from levying the FPPA.
So here in the month of April, you need to charge FPPA,
Perhaps if,
isn't it?
or what they do usually, because it's sort of a running account. If somebody has been undercharged or overcharged, it's made up in the later months. That is the process followed.
But FPPA has to be charged as per the schedule,
It has to be charged as per
as per the regulation.
as per the regulation. It has to be charged.
Has to be charged.
Has to be
For
charged.
the month of April, you charge. Is it required to be notified prior to that?
Okay. Yes, what what the officer is telling me, Your Lordship, is earlier around 10 years ago, 2013-14, again the FPPA had once again previously been subsumed into the tariff. So and on that occasion, almost 10 years back, the AERC had restricted us from levying the FPPA again because that would amount to double, to charging them twice. So this time also they assumed that the same process would follow. That is why for the month of April, they had not done it.
No, how is the FPPA charged?
It is charged as per the formula. Your Lordship.
Implementation, you see the FPPA 5.1
Yes,
will be recovered in the form of an incremental energy charge
incremental energy charge.
in proportion to the energy consumption and will be forming a part of the energy bill to be served on monthly or any other periodical basis.
So it has to be a part of the bill, Your Lordship.
It has to be a part.
It has to be a part of the bill.
So if it is not there, you need to charge them for the month of April.
That is perhaps one. That is.
Does it say that you cannot charge it?
No, it
also?
doesn't. It says that it has to be a part.
Then, so I think you should issue revised bill to the petitioner.
They have said that. Yes, they have said that this has been adjusted in the rate
Where?
because this was not applied for any consumer, Your Lordship, for the month of April. After it truing up for the subsequent period by the AERC, this has been adjusted. This non-charge, this
Exempted.
adjusted, Your Lordship. This non-charging for a month, this shortfall which has been faced by suffered by APDCL, that has been adjusted in the rate for the next subsequent months.
So for the month of May, June and July.
Yes, there is a new tariff order passed in March 25, 2025. The year. Next page.
What do you say about 5.10?
Because this, what the officers informed me, perhaps this is the power which which the ARC is exercising now for the subsequent year. The power under 5.10, the shortfall under in the previous year is ought to be
Can
made up now.
include a prior period expense for the recovery in subsequent quarters if it can prove to the satisfaction of the AERC that the details of expenses claimed were not available for reasons beyond the control of the man at the time of filing.
Yes. So the fact is that because of this, I would say lack of communication between the ARC and the APDCL, for April, FPPA was not charged. In fact, Lordship, 5.13 may also be relevant. There's a prayer which has been made by the petitioner here that he has been overcharged. That can also perhaps be taken care of. 5.13.
Mr. Savala, if in terms with clause 5.11,
Yes,
5.10,
yes,
any recovery can be made for the early period,
yes.
then how do you withstand your argument, which you say that it has to be informed in the month of April for the month of May?
Well, that is another aspect of matter, my lord.
And this
If
is
it-
the
well,
aspect
Because
which
they have fixed in the tariff, my lord.
no, understood.
Yes.
If there was a mistake committed by them also,
Yes,
or if there was not done also,
yes.
they can still recover.
Well, that is in the form of tariff. That is in the form
No,
of
no.
tariff, my lord.
They can include a prior period expense for recovery of the subsequent quarter if it proved to the satisfaction of the ASC that the details of the expenses claimed were not available for reasons beyond the control of the time of filing.
My lord.
Now they say that look here, we have made the request to the ARC. ARC did not initially provide all the details out there. It was only given in the month of April. So from the month of May, we make the and this is the recovery which is being sought to be made. So what is wrong with this? Means your submission, which you are saying that for the month of May, as it was done at the end of May,
My lord.
you could not have charged for the month of May.
Yes.
That submission cannot withstand taking into account 5.10, meaning thereby the distribution authority has the power even to recover if there is anything left out after due taking from the permission from the AERC.
Well, that they have to take permission from the ARC, my
So
lord.
that is what they have taken. That is why they have, that is their stand. Then look here, we have asked the ARC gave the clarification for that. We continue to include for the month of April also, we continue to include. But for the month of May onwards, we have done it in the month of June and by issuing that notification, which was done on 23rd of May 2023. So therefore, their submission is, we can verify, we have taken the due permission from the ARC. And in that process, we have done so. And how do you say that for the month of April, May, June, May, you have to give it in the month of either the first day of the month of May or at the end of April? That is your submission. How do you withstand that when they have still the power under 5.10 to make a recovery of the earlier period?
That is, my lord, whether ARC give permission or not, that is another aspect of matter, my lord.
That is another
That
aspect,
is-
but the fact
That is,
that they
the
have the
facts, my
power.
lord. But
But is it your contention out here that
No,
ARC have not given permission and then also they have taken it?
no, otherwise, my lord, they cannot do it, my lord. My submission is this, it is given retrospective effect, my lord. That is all.
Why? Because if you look 5.10,
Well-
it gives the permission.
Huh? My lord, it will be contradictory to 5.5, my lord.
No, 5.5 is different.
Yes.
5.5 is for every quarter of a year.
Yes, but FPA charge shall, for a quarter shall be charged from the first of the next quarter.
Yes. So
Well,
therefore,
So first of the next quarter, my lord, it will charge. So this notice, if it is given retrospective, my lord,
every
is-
period shall be a quarter of a 3 months.
3 months.
Accordingly, distribution shall compute and adjust the amount as so and so.
yes.
Thus, FPPA charges for a quarter shall be charged from the first
of the next
month
quarter, my
of
lord.
the next quarter.
Next quarter. So when notice is issued, it will be from the next quarter, my lord. Whether they recover it or not, that's a different aspect of altogether, my lord. They may be recovered, that is another aspect of matter. But they cannot charge it, my lord. This is what I mean. For May, they cannot charge it, my lord. Similarly, for the month of September, yeah, subsequent notice. They may recover, that is another aspect after taking permission from AIS.
But they can even recover for the month of April also.
They can let them, my lord, that is another aspect of matter. I am not on that, my lord. If they can, they have to apply to the ARC, my lord, if ARC, apply, my lord, that is another aspect of matter. That we can, maybe, we can change that one.
So you are on this, no? The
Yes.
FPPA charge for a
Yes.
quarter
Yes.
shall be charged from the first month of the next quarter.
This one. That-
যেতিয়া মোৰ fixment হৈ গ'ল, তাৰে পিছত বহি calculate কৰিব, কৰি কিনে মোৰ consumption ৰ পিছত এইটো calculation কৰিম।
Paragraph 3. Two হৈ গ'ল, now paragraph 4. The petitioner herein have a sale have sought for a writ in the nature of mandamus and have a sale. The notice dated 27/5/2023 whereby
929, 923, my lord.
wait. Whereby the FPPPA surcharge was included in the bill for the period bill dated 12/6/2023 for the bill period 1st of May 2023 to 31/5/2023. Though the notice notice dated 27/5/2023 categorically mandated that the rates mentioned therein shall be levied for the next 3 months with effect from June 2023. Mr. G.N. Sahewala, the learned senior counsel appearing on behalf of the petitioner, submitted, drawing the attention to clause 5.5, that each control period shall be a quarter year, that is 3 months, and the computation of the FPPPA surcharge has to be made by the distribution licensee for the quarter, which shall be charged from the first of the next quarter. The learned senior counsel therefore submitted that on the basis of the said notice dated 27/5/2023, the FPPPA surcharge could have been charged only from the month of June to August 2023, and not for the period of May 2023. The learned counsel, senior counsel, further drawing the attention to the notice dated 29/9/2023, made a similar submission that the said FPPA surcharge has to be charged for the months of October, November, and December 2023, and not for the month of September 2023, as have been done by the bill dated 11/10/2023, which is the bill period for 1st of September 2023 to 30th of September 2023. The learned senior counsel, with all fairness, submit that for the bill period from 1st of September 2023 to 30th of September 2023, FPPA surcharge shall be on the basis of the notice dated 27/5/2023 and not on the basis of notice dated 29/9/2023. এখন দুখন petitioner দুটা order এখনৰো facts দুখন এই submission একেই হ'ব এইখিনি খালি date কেইটা বেলেগ the said submission, the details of the said submission was also applied in the case in the case of the petitioner in WPC number 720/2024, wherein the learned counsel submitted that in respect to the bill dated 12/6/2023, in respect to the consumer meter, in respect to the meter number 06/01898, for the period from 1st of May 2023 to 31st of May 2023, the FPPA charge could not have been levied on the basis of the notice dated 27/5/2023. Further to that, in respect to the bill dated 11th of October 2023, in respect to the same meter, the FPPA charge could not have been levied on the basis of the notice dated 29/9/2023. Rather, the FPPA charge would have been levied on the basis of the notice dated 27/5/2023. Full stop. Mr. K.P. Pathak, the learned standing counsel appearing on behalf of the APDCL, submitted that the imposition of the fuel and power purchase price adjustment (FPPA) is a necessary economic instrument to ensure that the distribution licensee like APDCL are able to recover uncontrollable and unforeseen variation in fuel and power procurement costs. He submitted that these costs are dynamic, subject to market fluctuations, and not factored into the base tariff. It was further submitted that without such adjustment, the financial viability of the licensee would be severely affected, ultimately impairing its capacity to maintain uninterrupted power supply from an investment in infrastructure and meet regulatory obligations. The learned counsel further submitted that as per the provision of clause 5.1 of the regulation of 2010, the FPPA is a incremental energy charge which is recoverable in proportion to the energy consumption and would be forming a part of the energy bill to be served on monthly or any other periodical basis. Referring to the case of the petitioner, the learned counsel submitted that the petitioner is a postpaid consumer and the electricity charges for the particular month are computed and bills are generated only at the end of the month. The learned counsel, standing counsel further submitted that the contention that the impugned notices dated 27/5/2023 and 29/9/2023 amounts to retrospective levy is misconceived and untenable. Inasmuch as in commercial power supply arrangements, billing for energy consumption always operates in areas. The learned counsels further submitted that in terms with the provisions of clause 5.5 of the regulation of 2010, the FPPA charge was computed and billed on deferred basis, with consumption in one quarter being billed in the subsequent quarter based on data availability from generators and power suppliers. The FPPA surcharge for the control period comprising from January to March 2023 was computed in accordance with clause 5.5 of the regulations of 2010. The relevant bills and the data for this quarter became available in April 2023. However, by retail order dated 29/3/2023, the respondent number, what is that respondent number? AIERC?
Respond number 3, Your Lordship.
The respondent number 3 revised the retail tariff.
Four.
The respondent number 4 revised the retail tariff for financial year 2023-24 effective from 1/4/2023 and subsumed the then prevailing FPPA of 0.50 per kilowatt into the base tariff. Under such circumstances, without regulatory clarity, the respondent epidicial were refrained from levying FPPA for consumption during the month of April 2023. Thereafter, in order to resolve such ambiguity, the respondent epidicial sought clarification from the respondent number 4 on whether FPPA could be levied for prior consumption in the light of the tariff revision. The respondent epidicial was informed by the respondent number 4 that such levy could be issued in terms with the regulations of 2010, and a formal communication to that effect was issued on 30/5/2023. It was further submitted that due to the aforesaid ambiguity, the FPPA calculated for the month of January to March were levied from May. And in fact, the petitioner was given a deferment of a month, April, for levy of the revised FPPA, which was calculated for the control period of January-March. The learned counsel further submitted that the petitioner have already obtained the benefit of change in the fuel and power purchase prices during the control period of January - March, besides also getting a waiver for the month of April, cannot be permitted to object to the levy of charge in the subsequent months. It was further mentioned that the FPPA it was further submitted that for the FPPA for the next control period, April-June 2023, was revised and notified by APTCL. Notice dated 29/9/2023 with effect from August. That is only after completion of the period of 3 months of implementation of the previous rate of FPPA, so that no consumer is unduly affected, and the mandate of clause 5.5 of the regulation of 2010 for levy of the revised FPPA for a period of 3 consecutive months is duly complied with. In addition to that, the learned counsel submitted that the petitioner has an alternative remedy in terms with clause 5.16 of the regulations of 2010. Determination and analyze. The regulations of 2010 were made in terms with section 61D, 62(4), 86(1)(b), subsection 1 of section 181, clause ZP of subsection 2 of section 181 of the Electricity Act 2003, whereby the Assam Electricity Regulatory Commission have been empowered to make the regulations. From a perusal of the said regulations, more particularly clause 5.1, it is apparent that the FPPA, which is the fuel and power purchase price adjustment surcharge, has to be recovered in the form of an incremental energy charge in proportion to the energy consumption, and would be forming a part of the energy bill to be served on monthly or any other periodical basis. The manner in which the FPPA surcharge would be calculated has been specifically dealt with in Regulation 4. Clause 5.2 and 5.3 provides that the distribution licensee upon being informed by the generating company, about the FPPA charge incurred, shall recover it from the end consumers. There is no denial to the fact that the FPPA charge is an amount leviable in terms with the regulation of 2010, with effect from 31st of March 2012, in terms with clause 5.4 of the regulation of 2010, would be leviable from 10th of April 2012. In terms with clause 5.4 of the regulation of 2010. Clause 5.4 further 5.2 and a further reading of clause 5.2 and clause 5.3 further stipulates as to how the formula for fixation of the charge, FPPA charge, is to be applied. And in the circumstance, the FPPA charge exceeds 25% of the variable component of the tariff, there is a requirement for the distribution licensee to file a petition to the respondent number 4 for recovery of the charges over the specified cap. And the same can be only recovered after the respondent number 4 scrutiny and directives. It is also very pertinent to take note of clause 5.3 empowers the respondent number 4 upon reconciliation of the relevant details provided by the generating company at the end of each quarter to carry out reconciliation. And if during reconciliation it is found that there is any discrepancy, the respondent number 4 has been empowered to issue appropriate directives for being adjusted in the next quarter. In the above perspective, this court finds it pertinent to take note of clause 5.5, which is the bone of contention. The said clause being relevant is reproduced herein under page 28. From a perusal of the said clause, say the regulation, from a perusal of the above quoted regulation 5.5, a clause of regulation, it will be seen that the control period, every control period shall be a quarter year, that is 3 months. It is further seen that the licensee had been obligated to compute and adjust the amount as fuel and power purchase surcharge. And this FPPA surcharge for a quarter shall be charged from the first of the next quarter. From a reading of the said clause, said regulation 5.5, it appears that the computation of the FPPA charge for the control period of 3 months has to be charged only from the first month of the next quarter. Or in other words, for the period for which the computation as regards the FPPA surcharge is made cannot be charged for the said period. As an illustration, if the control period is for the month of January to March, the computation, the distribution licensee is obligated to compute the FPPA surcharge for the period for January to March and charge the same from the first month that is April of the next quarter. This code further finds it relevant to take note of clause 5.6, which being pertinent, being relevant to the contentions raised in the instant proceedings, is reproduced herein under. A perusal of the above quoted regulation 5.6 stipulates that the fuel surcharge formula shall be applicable to the distribution licensee till it is amended either on a petition or suo motu. And further, the FPPA formula would be applicable for all consumers unless exempted by the Commission. This aspect of the matter is important, taking into account the submissions so made by the learned senior counsel appearing on behalf of the petitioner, that for the month of September 2023, the FPPA charge so fixed by the notice dated 27/5/2025 shall be applicable, taking into account that there was no other notice issued till the notice issued on 29/9/2023.
Shiv, I'm really sorry, but perhaps that may not be the correct interpretation because it is talking about the formula, Your Lordship, not the rate. Perhaps that
No. The fuel surcharge formula
is given at
shall be
clause 4.
applicable to the distributed. No, kindly see there. The next year.
5.6.
5.6.
The FPPA will be applicable for all years unless exempt.
So the formula is given at 4. But I'm just placing it
The
for a
fuel
Lordship's consideration.
surcharge formula shall be applicable to the. What is this formula?
The formula is, I think it's referring to the formula at clause 4, regulation 4.
No, the formula cannot change.
Because the formula,
You see, this is the how you are doing it. Kindly see here.
Because regulation 4 says the formula is FPPA, formula is the formula given at regulation 4. So perhaps it's leaving a scope for change of the formula. Perhaps that may be one.
Itu 5.62 tadi. This court further takes note of clause 5.10 of the regulation of 2010, which empowers the distribution licensee to include a prior period expense for recovery in subsequent quarters if it can be proved to the satisfaction of the AERC that the details of expenses claimed were not available for reasons beyond the control of the distribution licensee at the time of filing. Clause 5.13 of the regulation of 2010 further stipulates that any calculation and levy of the FPPA charge shall be subject to scrutiny of the Commission, and the Commission shall make available the calculation of the licensee or generating company for inspection by any person. The licensee or the generating company shall refund or recover, as the case may be, any difference of such surcharge already recovered by it and approved by the Commission. Clause 5.5, 5.16 further stipulates that in case of any dispute, an appropriate petition in accordance with the Assam Electricity Regulatory Commission Conduct of Business Regulation 2004 as amended from time to time, or any statutory or reenactment thereof, shall be made before the Commission. It is on the basis of clause 5.16, the learned counsel appearing on behalf of the respondent APDCL submits that the petitioner ought to have approached the Assam the respondent number 4 rather than approaching this court. Full stop. In the backdrop of the above, analysis of clause 5, which is the implementation of the formula as mandated in clause 4 of the regulation of 2010, it appears that for the month of, it appears from a reading of the notice dated 27/5/2023, as well as 29/9/2023, that the rates so stipulated therein as the FPPA rate shall be chargeable in the next quarter. That is, for the sake of clarity, in respect to the notice dated 27/5/2023, the rate mentioned pertaining to the FPPA would be charged from the month of June 2023 onwards. And until any change is being carried out by issuance of separate notices. However, while applying the said notice dated 27/5/2023 in respect to both the meters of the petitioner, the FPPA charge have been included for the bill period 1st of May 2023 to 31st of May 2023 by bills dated 12th of June 2023, which in the opinion of this court is not only contrary to clause 5.5 but also contrary to the notice dated 27/5/2023. This court further takes note of further to that, the notice dated 29/9/2023 as well as the rates mentioned therein has to be applied for the period from October to December 2023, October onwards, and not for the bill period of September. Therefore, the bills which have been issued on 11th of October 2023 in respect to both the meters of the petitioner for the period from 1st of September 2023 to 30th of September 2023 could not have included the FPPA charge at the rate so fixed by the notice dated 29/9/2023. Accordingly, this court therefore disposes of the instant writ petition with the following observations and directions. The respondents herein, the bill dated 12th of June 2023 in respect to consumer numbers, consumer numbers এটা 1897 and 1898 তাৰ আগত 08 1897 meter number. Both are same date, na?
Yes, yes.
For the bill period 1st of May 2023 to 31st of May 2023 could not have included the FPPA charge as fixed by the notice dated 27/5/2023. Number 2. The bills dated 11th of October 2023 in respect to consumer number so and so, for the bill period 1st of September 2023 to 30th of September 2023 could not have charged could not have incorporated the FPPA charge on the basis of the notice dated 29/9/2023 and taking into account that the admitted stand of the respondents that after 27/5/2000 after the notice dated 27/5/2023 till 29/9/2023 there was no fixation of FPPA charge by issuance of any notice. the FPPA, which is ought to have been charged in respect to the bills dated 11th of October 2023, had to be charged on the basis of the rates fixed as per the notice dated 27/5/2023. Number 3. This code further directs that on the basis of the above observations, the petitioner would be entitled to certain refunds in respect to the bills dated 12th of June 2023 for the bill period of 1st of May 2023 to 31st of May 2023, and the bill dated 11th of October 2023 for the bill period from 1st of September 2023 to 30th of September 2023. And the said amount shall be adjusted against the future dues of the petitioner. This number. This court, however, grants the liberty to the respondent official, if so advised, to take appropriate steps in terms with clause 5.10 of the regulation of 2010 to seek any recovery if so permitted by the respondent number 4. With the above, both the petitions and you don't require this.
No.
If you have brought that, then it would go against your contention. We'll wait one, just wait. All 16. Oh.
Item 16.
This is challenging award, no?
Award Lordship, page 128. Passed by presiding officer, Labour Court, Guwahati.
128.
128 Lordship. Annexure 12.
What was the petitioner, the workman working as?
Workman as a Lordship employee in the Bata India Limited, is a temporary employee Lordship.
Hmm?
On temporarily wage basis, he was employed under the rule of Bata India Limited at Lakhimpur branch.
As what?
As daily salesperson Lordship.
Do you come within the ambit of a workman?
Lordship, what happened in this case, Lordship?
Hmm?
Till 2008, Lordship, I was work under the Bata India Limited, Lordship.
As
As workman on daily wage basis, Lord.
in where?
In Bata India
No,
Limited,
no, you are
Lakhimpur Bus.
saying yourself to be a workman.
Yes,
But do you not come under the, you were working as a salesperson.
salesperson, Lordship.
Salesperson, if you are working as a salesperson,
Lordship.
would you come under the workman or would you come within the ambit of what you call, you were working in a shop,
Bata store,
not a store.
Bata store.
If you are working in a store,
So,
would you come within the ambit of under the Assam Software Establishment Act?
Assam Software Establishment Act, under that Assam definition, and the Industrial Dispute Act also, I come under the workman lordship as per under the
You are saying that you are a workman because you work out there for more than 200 something days.
yes, yes,
And as such, you are a workman.
lordship.
That is okay. But are you a workman? Industrial. Taking into account,
Yes.
won't you come under the Assam Software Establishment?
A person employed in any industry, but that store is not come within the ambit of
You had nothing to do with the industry.
yes,
Though even if we take the extended definition of industry also,
yes,
would you come within the ambit of industry?
perhaps not lordship.
You don't come within the ambit of it. Can there be an industrial dispute? You check out the Assam Software Establishment Act, whether the Industrial Disputes Act have been legislatively incorporated. If it is done so, it is okay. Otherwise, because you were working as a salesperson.
Yes.
Then you were terminated
Lordship.
and you were put into another job because what has happened, Bata, I think 2008-9, this
8,
must
9.
happen in 11-12, na?
Yes,
They changed,
this is
if I'm not wrong. So
Yes.
they changed and they have become a different
Contact
setup altogether.
also.
They've started having these K shops and all.
Yes,
And therefore you were asked to join there.
Yes.
So whether you will come within, because these are shops
Yeah.
under the Assam Software and stuff. You
Lordship,
find out.
let me check lordship whether this can be come within the ambit of
Because
industry.
I don't want to just dismiss it for default.
Yes,
If I just dismiss it for default, then tomorrow there will be the thing is, he will come again for restoration. I think most probably Mr. T. Roy was there.
Tapan Roy.
He's no longer there.
I informed him yesterday.
Then what does he say?
Then he has actually what happened was in this case, management has in default of payment of 17B.
17B has
Yes.
not been paid.
Some amount has been paid, but still 3,67,000 is yet to be paid. Some arrear amount from the date of award till the date of filing, and from January 2025 till today they have not paid. And he has taken permission from the court to obtain instruction in this regard of payment. That instruction he has not received. That's why he has not appeared. From April 2019 till December 2024, they have paid. But from the date of award till Lordship March 2019, they have not paid the arrear amount.
What are you doing presently?
Presently, I'm not doing anything. Lordship. I have also submitted my affidavit to that effect also. I'm not involved in any occupation.
What is your age?
Age Lordship
Where is your affidavit?
My affidavit.
Oh, no, I actually asking.
Lordship 43 years as on Lordship. In 2014, I was in 43 years,
10 years.
10 years, 53 years. Lordship.
Yeah, your appointment order is Annexure 5.
Have Lordship.
So and so, Iman, employee number, so and so. Contract will comment on Iman and expire on Iman. During which you will render service to the client at premises subject to the terms of engagement letter executed by you on Iman and in accordance with the construction received by you from me. You shall fully perform the services in a professional manner at the client completion of the term.
Page 23 is my initial appointment particulars at Bata Lordship. Page 23.
You were born in 1970.
Lordship.
Now you'll be 55.
55.
Where's the appointment letter?
That page 23 Lordship, date of appointment is written Lordship 25/12/2016 last column.
You resigned also.
Lordship, that is the bone of contention that in the name of Lordship regularizing me, I was forced to resign. This was the case. They took signature in certain papers, Lordship, and also called me to the Kolkata also. I have annexed the evidence of train ticket and hotel register, everything.
Then you have given a full and final settlement.
Settlement, Lordship.
Temporary salesman, cashier, top assistant purely on temporary basis at Iman.
Lordship.
Since I am living on my own personal reasons. Appointment letter. This happened when?
And there's
2008.
Act.
Then you are given an appointment letter.
Appointment Annex 5, page 29. In
This is
team list.
subsequent.
It is subsequent. 29/9/2008.
Where is your original appointment letter?
That appointment letter is not on record, but this is the annexure 2, page 23 is showing that I was appointed.
And you have accepted this appointment letter.
Yes, Lordship.
Then? What do you mean? Then you have been terminated from that.
Yes.
Who has given you the appointment here?
The team list, Lordship.
Team lead.
Team list. That annexure 5 was issued by team list.
So therefore, when did that industrial dispute start?
Industrial dispute start after my termination from team list, Lordship.
Huh?
After my termination from team list.
Then why is Bata there?
Actually, Bata was the principal employer. I was all along with the Bata. That I was compelled to join in team list. Lordship.
But you joined
Yes,
in 2011 without any
yes,
problem.
without any protest.
Then how does team leads begin? Then
And then Lordship, thereafter Lordship, during the proceeding before the Loiba court below, they have admitted everything that how I was transformed from Bata India to team list.
so, but you worked out there in team lead.
Yes, yes, Lordship. That I cannot avoid, Lordship.
Then The workman requested that as per the letter dated, the tenure of the year was supposed to be completed on demand, but the management did not extend the services of the workman as on demand, nor terminated his termination, rather allowed her to continue. The workman requested that he was paid his salary up to December. After that, the management had stopped paying the salaries and so and so. But how is
Page 111 was the contention of the workman lordship.
1-1?
One, triple one lordship page. It was evidence in chief in affidavit lordship. And the same as the written statement filed by the workman.
This is your evidence on affidavit. It's okay.
This is the
This is of
contention.
2008.
8. And this is the
Team
contention.
leads.
The in the-
I further said that even my signature in the appointment was obtained by the then manager of Bata shop,
Yes,
namely Aravind Thal. In this process, my services was utilized by the manager as sales promoter. Team leads is different. How do you bring team leads and Bata company together?
team lead is not the party before the labor court.
Understood, but how do you bring team leads and Bata? You
Because-
must be saying that you are actually not in view of the contractual act,
Yes.
abolition of
Team
contractual.
lead. And I was working in the Bata store under the team lead. In the same establishment.
Where is it? Because your appointment letter doesn't say from team leads. Who was making the ESI contribution?
Perhaps team lead lordship.
Then how are you bringing Bata out?
Definitely lordship. After, yes, lordship, I must admit that after Annexure 5, I am no longer permanent employee under Bata.
No,
I
you have
I
to
came under the
show
I came under the Contract Labor Regulation and Prohibition Act under team lead lordship.
under team lead, but
Team lead.
actually you have to show somehow
Yes,
that team lead was just a contractor
yes,
under Bata.
yes. They have
And
admitted.
it was used as a camouflage
Yes,
to change the situation.
Yes.
This is what you have to show.
yes, yes.
Where is it? How was that proved? Where is the finding?
Lordship, I am.
The company has engaged another person in his name, Iman, on daily wages, having returned to the workman approached the labor office from Iman. Where is that finding?
Lordship, page 133. The last
On the
sentence
other
of
hand,
the
according to the management witness number one,
The last part,
voluntary
one
resigned
paragraph, last
the
sentence.
company by
During his
resignation,
cross-examination,
due salary in Iman till date, and he has then proved that when in cross-examination, he admits the contents of parent. On perusal, it appears that in the state paragraph, here the workman side that claims that the manager has issued from the cross-examination. I know the management of the- Now here the finding, the claims of the workman examined as where in support of his claims made in his written statement that thereafter he had to serve under team lead and the said team lead was an outsourcing agent of management of Bata Limited
Yes.
and also not in dispute.
during
Where is your statement out there?
and during his cross-examination of AMW1, also admitted that Bata India Limited is the principal employer of Team List Limited.
Case of the management side has deviated from the Iman of the Iman is that Kindly come to page your cross.
Lordship.
At present, I am engaged in a private shop.
Lordship. That point of time.
At present.
Yes.
So
Yes.
meaning thereby how full back wages were given to you?
Uh, After that award, Lordship, I have no job, Lordship.
No, I'm asking you how. I filed this petition because I was terminated. I filed this case against Bata India. I was working in here since 2001. I cannot say whether I have submitted documents to show that I was working in here since 2000. Not the fact that I was working in Bata since 2006. I did not resign from signature put in here of the workman. Of the written statement of the workman is signed by me under objection. My evidence, I had stated the work management had played fraud with me and thereby put my signature in the printed resignation letter on Iman provided full and final settlement. I put my signature. Whether any documents submitted were in connection with the fraud committed by the year. I did not lodge complaint or FIR against Bata India for committing fraud. Full and final settlement that I have received my due in full and till date I have worked and I have no claim whatsoever at any nature against it. The company asked me to put signature in some document. At the time of putting there, I had no knowledge that the state documents are resignation letter. The management did not threaten me at the time of putting signature. I had not submitted any document to show that Bata compelled me to work. Exhibit A, which I have submitted, is the appointment letter issued by team lead. I put my signature in Exhibit A, the appointment issued by team lead. Contention of para 7 in Exhibit A is correct. I have not submitted any documents to show that I put my signature before Bata India. Salary slip was issued by team leads. That is CDE. In paragraph 7, I have stated that I have received salary up to the month of December 2010, but I have not mentioned that the management had stopped salary by not specifically mentioned the name of the management. I have not submitted any to show the management called me to Kolkata for interview. The company did not send calling letter. Though I appeared in the interview at Kolkata, but I have not submitted any document to them. I sent letter to Bata India not apprising them for not getting salary by reason, but I have not submitted receipt or demand. After resignation, I working under team lead staff solution. It is not a fact that I have not mentioned in my evidence on affidavit that I did not work in Bata India. I've gone through the written statement as well as the evidence on I'm looking at the back on 3 years. I cannot say who was the district manager in 2001. I do not know who was the district manager in the Bora was the immediate. So I have no knowledge. Store manager is the best person who knows their way to field management. The can something which is at left at the it will say where it is now. Now the vacancy that Here he says it is not a fact that Bata India Limited, being a principal employer, has control over team leads.
Yes.
While team leads is issuing any document, they also issue one copy to the management of it. It is not a fact that we have no control and supervision of AR. Exhibit A was issued on Iman showing poor performance of the workman. Exhibit A5 was issued on Iman wherein it is written in Exhibit A5 that he was consented and omitted to work during his tenure with us. It is not a fact that exhibit was a manufactured document only to deprive because of it. It is not a fact that termination of the workman without assigning any reason is not justified and proper. Not a fact that in entitled to reinstatement. I cannot say in 2008 the company notified about the change in the service. I have not submitted the original document of exhibit which I have relied upon. Not a fact. But Mr. Doctor, it is not your case about this contractual obligation, the contractual labor, this thing, no? Contract labor regulation and evolution act. It's not your case.
No, my case was that I was compelled to join as a contractual labor lordship under the team lease.
Show me one statement
Yes,
where you have
that-
mentioned
Page 40 lordship in my written statement
where
of my writ petition lordship, page 40, or this is my written statement. Page 40, paragraph 4. That Open was working in the Bata September.
without any prior knowledge or compelled him to work in the state Batasam under the team lead services limited and outsourcing agent under 12. The workman for the sake of maintaining his livelihood along with demand provided there by the then manager of Bata. It is we mentioned that initially the workman was appointed as sales promoter for a period of Well,
That outsourcing agent is come within the ambit of lordship contract labor regulation and prohibition act.
but you have to show that it was a camouflage. Nothing to that effect. First of all, whether you are a
That's it.
this is the most important thing. I don't think you come within them. That case. None appears on behalf of the petitioner on call. Mr. P.P. Datta appears on behalf of the respondent. It is seen that the petitioner is not represented before this court on various dates. That is on 8/5/2025, 5/8/2025, as well as on 12/8/2025. So taking into account the above, it seems that the petitioner have lost interest in the instant proceeding for which the petition stands dismissed for non-prosecution. Interim orders, if any, stands vacated. The records be returned after 90 days from the date of the instant order to the learned labor court. Labor court,
Labor court. Right.
Item 1. May it please your lordship, my lord. My lord, here, my lord, we have challenged the assessment of bill under section 126 of the Electricity Act, my lord. The allegation, my lord, here is tampering of the meter, my lord. But in the, my lord, assessment order, if lordship directly come to the assessment order, my lord, at page 94.
so
My lord,
you
here,
have been refunded 22 lakhs.
yes, my lord, they have adjusted with the, my lord, then dues, and now, my lord, the balance
This is
amount.
pursuant to the appellate court's order.
Yes, my lord, appellate court said, my lord, there is no unauthorized use of electricity, and thereby artificial is not in the loss. my lord, against that, so the appellate order said, my lord, the petitioner cannot be searched for the demand search. However, upheld the proceeding under 126, my lord. For preceding 12 months, this is not touched. The
Let us
demand
see the
search,
appellate court.
yes, my lord, that is important. And against that appellate order, my lord, they filed, my lord, page 192, my lord. They filed review against the order, and the review there, my lord, it is also important, my lord, that first, my lord, appellate order, 192. This is filed by us, my lord. Or my lord may directly come to page 197 also, my lord, because this is the way how they have deal with the, my lord.
No, this order of 22/3/2022. This is the order by the appellate authority.
Yes, my lord, yes, correct.
So here it category, in my belief, the tampering of the seals fixed on the top cover of the CPPT said was done by the appellant with a malified intention of tampering the metering system after 16/7.
My lord.
Tampering, then
No, no. My lord, here, my lord, the question is, my lord, that whether by the tampering or, my lord, theft, my lord, whether there is unauthorized use of, my lord, sanction load or not, this is the question, my lord. If
unauthorized use of.
unauthorized use of energy or not, my lord. If there is unauthorized use of energy, my lord, if
Yes,
there is
Electricity
126, my lord, then they can
After
initiate.
thoroughly examining the facts, I have come to the
Yes.
conclusion the appellant is guilty for tampering the seals of the metering system with dishonest interest, which is also an act of interference of metering system for theft of energy, thus affects penal action under 135.
My lord, yes, it is a case of 135.
Huh?
Even for argument's sake, my case is that it may be a base of case of 135 theft. But for the LS theft, I have not used the energy, my lord. And if there is no unauthorized use of energy, so under 126, you cannot, my lord, initiate an assessment proceeding. This is my submission.
What?
My lord, because that assessment proceeding was initiated under section 126.
Huh.
Which permits the authority for
Review
initiation
has
of
been filed,
proceeding.
The review filed by so and so.
Yes, now review is in my favor, my lord.
Involved in
The
meter
judicial
tampering
filed a
by
review.
so and so, the appellant on so and so. This proves that although the meter was tempered, this did not cause any loss to
Yes.
PDCL in realization of the demand charge from the respondent and also not benefited by the respondent in that. Therefore, the respondent cannot be billed to recover the demand charge in excess of their monthly bill demand charge, as the appellant has already billed.
For the same, which the respondent had already paid. I have already paid, my lord. That 12 months bill, my lord, and I have given the bills also in the annexure, my lord. That so far the bill for 12 months are concerned, this I have already paid page 199 to 210, my lord. Because so, my lord, 212 page, my lord, from the serial number F, my lord. Let me read this, my lord. 212, my lord. After careful consideration of all arguments as well as, my lord.
So there is theft.
My lord, yes.
How do both gel together?
There is a
126.
Supreme Court judgment, Your Lordship, in Orion Metals, where the Supreme Court has said that even in cases of theft of electricity, for assessment of the electricity charges under section 1A, which is mandatory, the procedure under section 126 has to be applied. 126 has to be applied.
126.
And it was upheld by there are judgments of a coordinate bench of this court and upheld in Chief-Alloys, Your Lordship.
No, but what is this review?
No, Here it has gone one step further. The petitioner has availed his statutory remedy under 127. In the statutory remedy, if your lordship has the operative portion at page number 197.
Appellate order.
Appellate order, of the order of the appellate order. I'm just referring to the last two paragraphs at the bottom of the page. After thoroughly examining the facts and circumstances, I've come to the conclusion that the appellant is guilty for tampering of the seals of the metering system with dishonest intention, which is also an act of interference of the metering system for theft of energy, thus attracting penal action under section 135 and 130 of the Indian Electricity Act 2003. To recover the loss occurred to the respondent due to suspected theft of energy committed by the appellant, the assessment of energy charge shall be made for a period of 12 months preceding the date of inspection on 1/1/2021. As per clause 126(6), there shall not be any assessment on a demand charge as no other unauthorized use of electricity was detected other than meter tampering. So what the appellate authority has in effect done, your lordship, is, lordship, electricity bill, when it is drawn on a consumer, there are two components of the tariff, your lordship. One is the fixed charge, your lordship, and one is the energy charge. The fixed charge, also the demand charge, the appellate authority says that don't levy the penalty of twice the tariff and 12 months on the demand charge. It should be confined to the energy charge. So against that, we filed the review, because the wording of section 126, in my humble understanding, it does not distinguish between the fixed charge and the energy charge. It just says the electricity charges.
Assessment under this section shall be made at a rate equal to twice the tariff.
It says twice the tariff.
For the relevant category service specified in subrule 5, subsection 5.
Yes.
Assessor reaches to the conclusion that unauthorized use of electricity has taken place, the assessment shall be made for the entire period during which such unauthorized use of electricity has taken place, and if, however, the period during which the unauthorized use of electricity has taken place cannot be ascertained, such period shall be limited to a period of 12 months
12.
preceding the date of inspection.
So therefore, my lord, unauthorized use of electricity is the, my lord, sine qua non, my lord, is the, my lord, issue to be decided first by the assessing officer before coming to having the satisfaction that for my lord, initiating proceeding under 126, my lord, that, my lord, there assessing, let us see, my lord, assessing officer order first, my lord. There is no iota of, my lord, this is even the wording is not there in the assessment order of assessing officer at page 96, my lord. This is the initiation, my lord.
Mr.
Yes.
Let's come to 197. In my belief,
Yes.
the tempering of the seals fixed on the top of CTPT set was
Yes.
done by the appellant with a malified intention for tempering of the meter system after 16/7/2020.
Yes.
Isn't it?
Yes.
Now, how do you take care with the definition of unauthorized use of electricity
Yes.
as defined in section in the explanation B
My lord.
of section 126?
My lord. Unauthorized use of
No, kindly look
Right.
to the book. We go as per books.
My lord. Yes. Yes. Utility means.
126 explanation.
That's correct.
There is no definition of unauthorized use.
My
of
lord,
electricity.
that has been, my lord, decided by the Honorable Court. So I placed that, my lord, as
We
well as
will
the,
see what this
Yes.
court has done.
if, my lord, kindly see, my lord, first wording, if on an inspection, first they will have on an inspection, my lord,
Come
that
to-
has been done.
come to unauthorized use of electricity means uses of electricity
Yes,
through a tempered meter.
yes.
This is a tempered meter.
My lord, we have not used that. My lord, that is to be proved in the criminal case, whether I have, because whether I have, my lord, tempered the meter or not, 135, that proceeding will be before the special court, and that civil liability will be decided there, my lord. Under 154 of this, my lord, Electricity Act. My lord, 100 and, just 1 second.
135 is for you to go to jail.
No, that's correct.
Yes.
But my lord, so far, my lord, civil liability is concerned.
Civil
that
liability is
hun-
126.
No, 154, my lord. 154
154
kindly
is
say, my
what?
lord. 150, that for the theft, if there is an, my lord, a proceeding under section 135,
And powers
Then,
of
in case of-
anything contained in the code of criminal, every offence punishable under 135 years shall be triable by a special court.
Yes,
It
now-
appeals to any court that on course of the inquiry.
Now, my lord, five, my
an
lord.
offence punishable under 35 has been committed. There has been a case which is triable by the constitution under demand for the area for which it shall transfer it there.
My lord, now, my lord, 5, my lord.
5.
Yes.
The
Subsection
special
five.
court shall
Yes,
determine
determine
the
civil liability against a consumer or a person in terms of money for theft of energy.
For theft of the energy
Yes.
which shall not be less than an amount equivalent to 2 times of the
Tariff applicable for.
rate applicable for a period of
Yes.
12 months.
Yes,
Preceding the date of detection of theft of demand or the exact period of theft, if determined, whichever is less, and the amount of civil liability so determined shall be recovered as if it was a decree of the civil court.
yes, my lord. So, my lord,
If
that,
the civil is so determined shall finally by the special court or say.
when the amount deposited the consumer or a person.
That is
My
relevant.
lord, now, my lord, here, my lord. So far, my argument is.
So you admit that it is a theft?
I don't,
Huh?
I don't, my lord. My lord, they may.
No, if you don't admit, then why not take recourse?
No, because, my lord,
126?
that is the work of the civil court and how they prove against me whether I have indulged in the, my lord, malpractice. That is for the 135 in the, my lord,
You
special
see,
court.
Whether 135 has been done or not, we are not concerned.
Yes,
But the fact is.
here in this case, they have done.
No, the appeal, the review has not been filed by you.
But.
Review has been filed by them.
Yes,
Now, what has happened, the court in the main order, your appeal order says that there is a case of tampering of the meter. Tampering of the meter comes within the ambit of unauthorized use of electricity.
my lord, for that, my lord, one assessment, one, my lord, aspect is to be considered by the appellate as well as the, my lord, assessing officer, that for malpractice done by you, this is the amount of unauthorized use of electricity by you for this period. That exercise not done in this case. Having not done that exercise, the what amount of unauthorized use of electricity has been, my lord, used or
Wait,
consumed.
wait. You have challenged, gone on appeal against what?
My lord, here, my lord, so far the appeal is concerned, demand charge, my lord, they have, my lord, exempted.
So they have therefore made an assessment.
Assessment,
That assessment, provisional assessment has become final assessment.
my lord,
Against that, you have filed an appeal under 133, 127.
127 years.
And 127 confirms that there has been unauthorized use of electricity.
This is under challenge, my lord. For
Yes.
saying that unauthorized use of electricity without determining the what is the, my lord, amount of energy that I use on the garb of saying that you indulge into malpractice.
No, no, no. Where
Yes.
does it say in the proviso to section, in the explanation to,
My lord.
explanation B of section 126? Does it
Even-
mean that unauthorized use of electricity means uses of electricity through a tempered meter? Does it say? Because it is an or.
20%.
Explanation one.
Yeah.
So explanation.
My lord, explanation, yes, my lord. Assessing officer, my lord, unauthorized use of electricity means use of electricity. My lord, use of electricity. Unauthorizedly use of electricity. They have to come to the conclusion, my lord.
Mr. Das, I also know that you are one of the very good advocates.
No,
Don't
no.
make this type of submissions before me.
No, because, my lord.
Unauthorized-
No, first, then, my lord, kindly see the opening, my lord, to 126, 1, my lord, first, my lord.
We will go to 126, one is gone.
Yes,
126, one is for inspection.
inspection as well as, my lord, the order of assessment to be passed by the assessing officer
Yes.
on being satisfied from the materials brought before him. So that
They will make-
for this
So,
purpose,
Mr. Garg, they will first make a provisional assessment.
yes, they have done that.
After that, you will
I-
be given an opportunity.
Yes, representation file.
You submitted, then they made a final assessment.
Final assessment done, my lord, yes.
Against the final assessment, you have gone under 125.
Appeal, my lord, yes.
127.
One to-
Now, again, the final assessment bill, what has been mentioned is they kindly don't, in the appellate order, they confirm that there was an unauthorized use of electricity.
My lord,
You see, here, clearly see the difference. Unauthorized use of means uses of electricity with a tempered meter.
my lord, for that purpose, my lord. And even the authority has gone for review, my lord. What is the review order, kindly, my lord, consider, my lord.
Yes.
That review order, what the review order says, my lord, in my humble submission, that relevant portion, page 212, my lord. Relevant portion F, my lord, kindly see, my lord. They have to do certain, my lord, procedure. F, my lord, kindly, after careful consideration of all arguments as well as examine the report, I have come to the conclusion that there shall not be any assessment of demands against the respondent, Kasar Alloys, based on the following evidence. Appellant AGM ICA Kasar did not perform any load security. This is the mandatory before assessment, my lord.
Mr. Counsel, wait.
Right.
This review was by them.
And there is an order.
Wait.
Yes.
Seeking more of a clarification. That look here, can we, that in respect to when you are asking us to take note of, make the final assessment in terms with 126.6. Can we, you have mentioned at this particular to recover the loss so and so for the 12 month, there shall not be any assessment on the demand charge. Large part at page 197, the last line.
Yes.
So they therefore sought for that look here, this demand charge also has to be brought within the ambit. This was negative by the review order saying that the question which
Demand
is
says does not arise.
demand. So
Yes.
this was on that aspect. Nothing else has been touched.
So, my lord, now, my lord, energy search will be, they will search.
Yes.
They have to search. And for that period in question, I have already paid the monthly bill for the energy search. Those bills I have received, I have placed, my lord. And therefore, 213, last line, my lord, as lordship pointed out, therefore, respondent cannot bill to recover the demand search. They have adjusted 22 lakhs. In excess of the monthly bill demand.
Where is the bill?
Yes, as the
Where
appellant
is
have
the
already
assessment
billed.
done under 126.6 after
lord.
the
Yes.
the appellate order, where is the assessment?
Right. My lord, after the appellate order, my lord, that lordship, this is the bill, my lord.
Don't show me a piece of paper unless you have brought it.
My lord, this is subsequent to, my lord, they have served, my lord.
Then what are you challenging here?
My lord, assessment proceeding is under challenge as well as the, my lord, appellate order, whereby it is said that, my lord, for malpractice, I have indulged into, my lord, and the proceeding under 126 is bad, my lord. On that count, I have challenged.
Why?
On the ground that, my lord, for initiation of proceeding, the one judgment, my lord, I will place, my lord. For initiation of proceeding under section 126, my lord, there must be the materials before the assessing officer that this particular person has or the company has indulged into, or, my lord, use of unauthorized use, my lord, use of electricity. What is the amount in kilowatt? They have to, in the 135, they have to assess it in kilowatt, because there is slab up to 100 kilowatt 6 months, up to 10 kilowatt, and then 20. The slabs are there. And moreover, my lord, yes,
Don't come to 135.
I will not, my lord. And this is clarified in the, my lord, Rajesh Sethi company also, my lord. Because here, my lord, that the assessment order was set aside, saying that you because there is no allegation of unauthorized use of electricity in your assessment order, therefore, by alleging only tempered the meter or theft of electricity, you cannot assess under 126. Therefore, this matter was set as a remanded back for fresh consideration, my lord. And even if lordship, my lord, founds, it's at base, it's a case of, my lord, for assessment under.
Whether there was tempering of the meter or not. That's a finding of fact.
My lord, it's a
Are you
case.
challenging the tempering of the meter?
I have stated in here, my lord, this is the question open for to be proved in the, my lord, 135 proceeding, my lord. Because they have.
That is
for-
for theft.
Yes, for alleging.
I am not on theft. I
My
am
lord.
saying whether there was tempering of meter or not.
My lord, what are the materials? Kindly say, my lord.
I am not on that.
No,
I am
one source.
asking you, Mr. Datt, whether there was tempering of the meter or not.
My lord, I have disputed that I don't know.
Go before.
Because only two materials they found, my lord. One torchlight. Torchlight is nothing to do with the, my lord, tempering of meter, and one outer seal, plastic seal cover. Because this meter is subject to, my lord, inspection every month. And torchlight, this inspection team, they are allowed to carry the torchlight as per their own regulation, my lord. So having found the torchlight inside the, my lord, CTPT, my lord, set, it will not prove that I have, my lord, indulged into unauthorized use of electricity, my lord. This is my submission. My lord, 178, 78 page kindly have a consider, my lord. Lordship kindly look into, my lord. This is the, my lord, notification circular.
Where is the first order passed?
Yes. First.
Appellate order passed. Where is it?
My lord, assessment order is at page 90.
First appellate order.
First appellate order, my lord, 192, my lord.
Has confirmed that the seals bearing number are different in certain electrical and physical parameters with those of the specimen used by APDC. But the seals of so and so are akin with each other. This report proves that the appellant was involved in meter tempering. Malpractice was done inside the CTPT set, for which the original seals of the top cover of the CTPT have been broken and which was replaced later with duplicate seals similar to the one in here. This is a finding of fact.
My lord.
Go before the civil court, fight it out. This is a finding of fact.
My lord, now, my lord, just once, my lord, judgment I will place, my lord. There, my lord, it is said, my lord, if on the basis of malpractice that has been alleged, if there is any loss or unauthorized, my lord, authorized use and unauthorized beyond the permissible limit, if I have been allowed to, my lord, that the sanction load is 3,400 kilowatt, and
Mr. Das, are we to interpret the explanation B to section 126 on the basis of a judgment?
no, my lord, this has been distinguished. My lord,
Fantastic. Show me.
yes, malpractice, my lord.
Let us also.
For the malpractice, there must be unauthorized use. If
I
not, my
I
lord,
also-
then that will
I
not
also
give rise to, my lord.
I
Yes, just one second.
show me what judgment. Yes, Dr. Todi, you are waiting for which matter? What is this? It has not reached. 7 to 8 to 9. Oh. Yes, Dr. Todi, what is the matter about?
Denial of payment of subsidy amount of TT garden matter.
Wait, what subsidy? Oh, the tea subsidy.
Yes, my lord, T subsidy.
There are few other matters of this Mr. What is his name? It's another lawyer now who does a lot of tax matters. How?
No, my lord, this is something different, my lord.
It's the subsidy.
Something different is subsidy, my lord, which was, my lord, although, my lord, everything was in order, but they were sitting over the matter and denial on it, my lord, tippling issue, my lord.
What issue?
They denied on a tippling issue, my lord, only very small issue.
Very small.
I issue, my lord, that because the financial year 15-16, my lord, the uprooting has to be done. Only, my lord, by clerical mistake, my lord, it wrote instead of March, April. And because of that, my lord, the whole subsidy amount was denied. This is the issue.
I thought the central government is not like the state government. And the central government has become like the PNRD.
Central government, they want to say that. It's a.
Yesterday, the funny part about the matter, a person concerned has quoted 2,43,500. He was, though highest he was not given,
Yeah.
the next highest was given 2,43,498. The reason is this person who have quoted 2,43,500 is 10.000098% higher. Which reminded me of our times where this Miss P.T. Usha did not get the bronze medal because of a 100th of a second. So at that time we were surprised 100th of a second would be, so how minute can it be? But now I realize that PNRD indulges in more minute details. So is it something like that?
It's actually a certificate with countersigned by them. It's a certificate countersigned by them.
Well, we do one thing. Let's finish it up on next Thursday, 2 o'clock.
Day after tomorrow.
We'll finish it up 2 o'clock.
The item number 8, my lord.
Yes.
Also,
If you want, otherwise this court doesn't have the luxury of time because I'm leaving for 2 weeks out and I'll deliver the judgment in the court. I won't wait for.
can be there.
Day after tomorrow, my lord.
Otherwise, if you want it, you'll have it after vacation. That's your urgency. I'm
The
not,
2nd of September was subject to Lordship convenience, my lord.
I'm not here.
Oh.
You want, I can read on 2nd of September.
Lordship is, my lord, Lordship.
I won't be here for 2 weeks.
Then
from
need to
20.
be on some other because Lordship had a hard day on the other day also.
No, I hear everything, I forget everything. Forget it. But the only, huh?
It can be any court.
So, my lord, day after tomorrow, my lord. let you-
On day after tomorrow, let's say it on 2nd of September. We'll have,
Day after tomorrow, my lord, it's a small issue, my lord.
because I have to deliver the judgment and all. So let it be on 2nd of September. And that I request of the councils, the matter stands adjourned to be listed again on 2nd of September. Yes.
Malo. The judgment malo 2012 malo 2 SCC malo. Executive Engineer Southern
Yes,
Electricity
others
Supply.
may go. Mr. Das has started with so
Lord.
many arguments, judgments.
Yes.
One,
There are 29, 30 and 61 malo.
three,
Kindly,
4. Yes.
because their distinction has been made malo.
Yes. Para
There are 29 letters. Let me read malo. Thus it would be
of
clear.
executive engineer.
Yes.
Para
29 malo. Thus it would be clear that the expression unauthorized use of electricity under section 126 of 2003 Act deals with case of unauthorized use even in absence of intention. This case would certainly be different from the case where is dishonest abstraction of electricity by any of method enlisted under 135 of the 2003 Act. A clear example would be where a consumer has used excessive load as against the installed load simpliciter and there is violation of terms and conditions of supply. I have not violated my law. Then the case would fall under 126 of the 2003 Act. On the other hand, where a consumer by any of the means method as specified in section 135 A to 135 E of the 2003 Act has abstracted energy with dishonest intention and without authorization, like providing for a direct connection bypassing the install meter, the case would fall under section 135 of the Act. 30, my lord. Therefore, there is a clear distinction between the case would fall under 126 of 2003 Act on the one hand and section 135 of 2003 Act on the other hand. There is no commonality between them in law. They operate in different and distinct field. The assessing officer has been vested with the power to pass provisional and final order of assessment in case of unauthorized use of electricity and cases of consumption of electricity beyond the connected load will squarely fall under such power. The legislative intention is to cover the cases of malpractice and unauthorized use of electricity and then theft which is governed by the provision of section 135 of 2003 Act. Now, what I understand from these two paragraphs, my lord,
So your long and short submission is,
keeping in
if
view of
you,
my
it's
review
a
order,
case of theft, there cannot be an assessment carried out.
under 126.
Assessment is only permissible under 126.
Right, right. Yes,
So
correct.
therefore, there is no assessment permissible. It has to be only by way of a fine in terms with 135 fine.
Or at best, I may add, my lord, or at best, if it is a case and because the assessing officer also said that this is a malpractice and theft, he has not said by malpractice and theft, you have indulged into unauthorized use of electricity. So that unauthorized is absent, my lord. What is important for 126? Therefore, at best, if it is a case of 135, they may impose, my lord, assess it for a theft, my lord.
So you mean to say tomorrow, no, wait.
Yes, right, my lord.
If tomorrow they fail to prove theft,
Yes.
then what?
If they fail to prove, my lord, then their case, their assessment is
Then
there.
are you open to pay the charges on a fresh assessment being made along with interest? I'm
My lord,
asking.
yes, sir. In such case, my lord, if
are
135,
ready.
if, my lord, for 135, my lord, what I understand, my lord, if under 135, it's a, they want to, my lord, assess, then it's a assessment under 5A44 of, my lord, of, my lord, electricity supply code regulated matter, I'm told, my lord, this has been repealed. However, in the, my lord,
No, at that point of time, it was going on.
no,
At that point,
my
it
lord, I'm
was
sorry.
not going.
No, yes, my lord, this is of 2004, my lord, 2007. And in that case, my lord, in fact, in this latest code also, there is a provision, my lord. Alleging theft pending disposal of the criminal trial, they can, my lord, for theft, this easy formula is there. They can adopt that. Not for, my lord, 126 for assessing for 12 months. This is bad. Because of the fact you fail to, my lord, hold that I indulge into, my lord, unauthorized use. Where is the use? I have not, they have, even themselves has not commented.
And what meter you are having?
My lord,
What type of meter it was?
high tension meter, my lord.
Understood. What meter is that?
Digital meter, my lord.
MDI.
Yes.
Then whether the 2009 amendment will come in, Mr. Pathak?
Lordship, I'll just,
At 7.2.4A or something like that.
yes, I do not know if the meter is it is a check meter. I do not know if it is a MVI meter. I'll
No.
check this out.
Meter is of, my lord. One second, my lord.
Don't you think matter requires a hearing in a
My lord,
in a weather where you don't have the AC and it is then also cold?
my lord, My urgency is there, my lord, keeping in the view of the urgency. And moreover, I can shortcut of this matter, my lord.
Yes.
In view of the
Yes,
judgment
shortcut
passed by the my lord, reviewing authority, my lord.
Huh?
Although they filed review, what the reviewing authority said, my lord? Reviewing authority said, as held by the appellate authority, don't search him, demand search.
Huh?
Don't search me, the demand search, which has been upheld in review also, and review has clarified what to be searched. Search for the energy bill for that period, and that has already been paid.
No.
Yes, my
no,
lord.
No, Mr. Das,
Yes.
that is not the question.
My lord.
You see, there are two components. I became a bit clever because there was another item which was I took up just now. There are two components.
My lord.
Now you have many more, 4, 5, 6. But there are primarily two components. One is the rate, the tariff. Tariff keeps on fluctuating or depending upon the tariff. The second is the demand. The demand charge which is there, these are peak charges, which are based upon the uses of the kilowatts which you are having. Just for example, you are a big consumer, so you must be having 1,000 kilowatts, and it is 10 rupees. So it is 10,000 rupees, which is the big charge.
Right.
There won't be any change. But the changes could be there in view of the dynamic nature, in view of the tariff which is there. The tariff could be keep on changing depending upon the use of the electricity.
My lord.
So the use of the electricity will be twice, or whatever may be, as per their regulation. That would be the total use of the electricity which will be taken if there is an unauthorized use.
My lord.
How there is a formula by which it will be done. And then for the last 12 months, it will be taken for that. And 12 months you have paid, and then subtract it and remaining you. Isn't it the simple equation?
Yes, sir. Because otherwise, once the meter is tampered, there is no way of determining what is
No,
the
no.
actual usage of the meter.
So
For
for
the-
the period prior to temper,
Yes.
prior to inspection, 12 months
12 months.
before. So what was the amount and what you have paid during the, isn't it?
Yes, Your Lordship. There is-
And there is some adding something.
yes, the formula is there. Basically, it's his tariff into his category. The
like
estimated
in the
use,
special category.
special category, there is a
some
chart.
payment.
Then the estimated usage per month into 2. And if it's the period can be determined, it will be for a shorter period or the longer period. If it cannot
And
be,
that has not been done. So it will be taken as 12 months.
it is taken as 12
And
months.
then minus it with what you have paid.
Oh, yes.
This is it. And therefore they returned you 22 lakhs.
Yes, Your Lordship.
Because my lord, so far that amount, demand amount, my lord, I paid in protest, entire amount.
Good.
And that entire amount they demand, my lord, because at that time I was
So for that they have returned you 22 lakhs.
22 lakhs.
And how much do you want?
My lord,
You say that I am willing, your argument something is like this. Look, I am ready to go to jail. I am ready to pay. Let's a special
my
tribunal.
lord, there, my lord, nowadays these cases are dropped, my lord. Below 3 years, my lord, these cases are dropped because
That's
punish.
why you are going on.
So criminal case, it will never be proved, my lord. And moreover, yes, my lord, from the judgment, there's a next judgment also. My lord, from
But
these,
how are these cases dropped? This is on a serious note. How are these cases dropped, taking into account that the liability can be fixed under one?
Yes, Lordship,
still-
when this notification was passed, issued by the government of Assam, I believe that the APDCL has written to the power department and which has now been taken up, that these are a special category of cases.
Because this can't be done.
Just on the
First
quantum of,
all, it has to be before the special judge.
yes, Your Lordship.
Secondly, the special judge have the power.
Yes,
If you
Lord.
drop it, then you cannot, the amount.
In fact, the problem which arises in these category of cases, even for compounding, unlike in the CRPC, here prior to compounding, a special amount has to be paid as penalty. That is also laid down in the Electricity Act. The simple provisions under the CRPC are not applicable.
And Mr. Das, your judgment which you are referring to,
My
let
lord.
me clarify very well. See the difference between theft and unauthorized use of electricity. There might be a case where a tampering of a meter, if it happens, it may be a case of theft as well as for unauthorized use of electricity. But if there is no dishonest intention,
Yes.
it would be simply a civil liability of the, we call the unauthorized use of electricity, and the assessment will be done with a reduced penalty.
My lord.
That's the difference.
My lord, to aid this, my lord, kindly have a look, my lord, the assessing officer order, my lord, just for a moment. Because this is the genesis of this case, my lord. How he has come to this conclusion, my lord, for initiating the proceeding, page 96, my lord. My lord, page 97.
Yes.
My lord, this is of dated, my lord, 9/12/2020. 21, yes, sorry. Request refers to inspection report of the inspection done in your electrical inspection on 1/10/2021 at your premise forensic report. There's a so-and-so director forensic report, Guwahati letter installation from CGM commercial. It is substantiated that there is sufficient evidence to conduct that tampering of meter.
Mr. Das, I don't take up criminal matters.
My lord.
But tomorrow means not, but you, I'm told, do a lot of criminal matters. So now, just tell me, in a complaint, if somebody doesn't put it, that he has committed cheating, but he puts the ingredients of cheating out there. Are you saying that
No, my
that
lord.
the case should be, the complaint should be?
My lord, obliged for this, my lord. I will address to that, my lord. My lord, therefore, my submission is that so far the initiation of this proceeding.
Yes, it is clearly human
this is-
tampering of the meter.
Yes, my lord, this is for, my lord, 135.
No, that is the explanation.
And because if we read this along with these two paragraph, my lord, para 29 and 30 of 2012, my lord, judgment. This is absolutely, my lord, clear. For the purpose of theft, he has booked me for
But
the.
where is
purpose of
it? No,
theft.
but Mr. Das, show me a judgment
Yes,
that when a case of unauthorized electricity, which also amounts to theft
yes.
with a dishonest intention, or
Yes.
make it more clear, an unauthorized use of electricity with dishonest intention, there is no requirement of assessment under 126. Show me. That's the crux.
Yes, my one judgment.
No, he has a lot of.
Oh, yes,
Yeah.
Leonard Friend is carrying it, so.
Don't do.
Foreign metals.
No, no. My lord, next judgment, my lord, 2020, 18 SCC, my lord. West Bengal State Electricity Distribution, they are also, my lord.
Versus the
If
right.
excess load is used by means of malpractice, my lord, then excess load I have to use, my lord. Para 9, 10 and 14. 9, my lord, this deal with the,
10 has been defined and 14 and all this. Let us.
my lord, kindly have a look at 14, my lord.
A perusal of the
14,
above,
my lord.
giving a conjoint reading of it appears to us that after inspection of a place of the imam, the assessing comes to a conclusion that he is indulging in unauthorized insolvency, the constitutional assessment to the patient judgment. This will be made in accordance with after giving it. Fine. You- you have to- See, paragraph 13,
30, my lord.
1-3.
1, 3, yes, my lord.
15 as well, your lordship. 15 as well.
Yes, my lord.
I
It is clear. And I was referring 14, my lord.
forget about 14, 13.
Yes, my lord. It is clear from the reading of 120 that the instance of case use of energy through tempered meter is included in the definition unauthorized use.
Read it further.
Yes. If that is so, there is no reason for excluding the power of authorities for making assessment under 126(1) of the case to assess the loss of energy where electricity is used through a tempered meter.
Hmm.
All instances of unauthorized use of electricity may not amount to theft electricity within the meaning of 135, but at the same time, the theft of electricity which is covered by section 135 of the Act will fall within the definition of unauthorized use of electricity. As per 135(1)(a) of the Act, without prejudice to the other provisions of the license supplier, as the case may be, upon detection of theft of energy, is empowered to disconnect the power supply immediately. Further, as per the third proviso 135(a) Act, that the license supplier, as the case may be, on deposit of payment, that has been done in my case, my lord, assess amount of electricity charges without prejudice to the obligation to lodge a complaint, can restore the power supply electricity within 48 hours of deposit payment of such amount. Thus, it is clear that the authorities under the Act are empowered to make a provisional and final assessment by invoking power 126 of the Act, even in case of where electricity is unauthorized used by way of theft, my lord. Therefore, my whole argument, my lord, there may be a gap of communication, my lord.
After this,
I-
you make an
yes.
argument per minute, 10,000 rupees cost.
My lord, one more judgment.
No
One,
problem.
the Rajastri team, my lord,
It starts at 443. You are
Lordship may
arguing
fix a date, my lord.
per
Some-
minute
my lord,
10,000.
two judgment I will place.
Something go to the DLSA.
My lord, that
Per
judgment I
minute,
already placed.
10,000 rupees. So
Just
per
two,
minute.
just 2 minutes, my lord. I pray, my lord. That judgment, my lord, WPC 93 to 17.
20,000.
I just have to lordship, my lord. My lord, kindly for, my lord, placing the judgment, a date may be fixed, my lord. Whatever order may be passed, my lord, it is. up
You
to
want
you.
another date?
Then, my lord, kindly this, or judgment to be looked into, my lord.
Yes, which one?
My lord, Rajastri Tea and Industries Private
What does
Limited.
it say?
Here, my lord, this 2012 judgment was taken into account, my lord, that para 26, my lord, 27, my lord.
Para 30 would also be written.
And definitely, that is very important. 26 and 30, my lord. Sorry, 27 and 30, my lord. The judgment in 2012, my lord, was, my lord, and para 30 of the judgment taken into account, my lord, and para 30, the honorable court has come to the conclusion, the prima facie, there must be established that use of unauthorized electricity in the assessment order. And here in this case also, my lord, that is lacking in the assessment order, my lord, therefore it was remanded back to the assessing officer, setting aside his assessment order. Yes, this is the case. Para 30. This must be argument, my lord. Raise the case to your lordship. Public.
So 2 minutes, 20,000.
Please, my lord. Forgive us, my lord, to
I gave a good time from 4 to 10 and you are showing me a judgment out here. Unnecessary.
I thought it proper, my lord, so my lord.
Huh? So that you don't later on say that I have not been allowed to argue in this court.
Yes, my lord, therefore, my lord, I placed that, my lord. For
So I
abundant
have given
caution,
you all the.
my lord,
Now,
lordship,
do you feel that I should give?
kindly
opportunity
inspire
to-
us, my lord, for making the submission, my lord.
Huh?
Because, my lord, if imposition of costs come, my lord, our submission will be restricted, my lord. So, my lord, kindly,
No, tell me anything more.
that's must, my lord. Lordship may take into account the review judgment, my lord. And on that basis, my lord, my entire argument was that, my lord, without there being quantifying the use of unauthorized absence, if whether I have used the, my lord, by tempering access to the, my lord, load sanction, you have not done that. So that goes to the root of the case of my case, my lord. Assessing officer never said, for malpractice, you have used this much of energy or you have exceed the limit. That is my case, my lord. Having said so, my lord, I could have understood.
No, first of all, tell me.
My lord,
How will the assessing officer know
my lord.
that you should have Actually, you used only 10 kilowatts, but you should actually, but he's showing as 15 kilowatts. How will the
So,
assessing
yes,
officer?
in another case, my lord, that also I am dealing with, my lord, there, my lord, assessing officer has gone into to the, my lord, productive level, my lord, my production, my lord. Last month or the before month and this month, the period for which tampering alleged, if my production is excessively high for this, for and he has then come to the conclusion there must be unauthorized use. Those are not here, my lord. He simply said you have tempered production. He has going to that level, my lord, because he will recover from some amount. There must be some in substance. Because
And this finding of fact, which has been mentioned in the page 97,
yes,
is being confirmed by the appellate court, saying that after making this forensic analysis, it is found that these seals which were there have been broken by you and you have replaced it by duplicate seals. This is the
This-
finding of fact.
yeah, this is one-sided.
This is the only side.
This is one-sided. This is subject to prove in the criminal court.
No,
And this is thoughts like
I'm not on the criminal side. Criminal side, the chief
yes,
justice-
my lord. Or
the chief
the,
justice has not given me the roster
Pro-
for that, and let's not go into that.
but my lord, here, my lord, unauthorized use that is not there because they fail to come to the conclusion calculation. What they have done in other cases, production they have seen for these 12 months. If production excessively high, yes, there is unauthorized. By malpractice, you have done the unauthorized use for 126. You are liable. So that consideration is not there. Dismiss. Oh, bless.
Anything more?
The first issue regarding applicability
We'll
of,
have it on Thursday next. Finish it up.
Very well.
Cut out.
very well.
Hearing remaining inconclusive, list this matter on Thursday at 10:30 AM. Final showing it as part.
Oh, bless.
Yes, Mr. Dasgupta, why are you waiting? And Mr.
Item is item
Diaspora,
number 12.
a person who is very
Item number
difficult.
13, that's the 2014 matter.
Which matter?
Item number 13, Lords.
So I could not mention it because mention for listing of matters for hearing is not.
A very old matter, na?
That is why I am saying it.
The long matter, Mr.
No, the short matter,
Short point. is-
very short point. Very short. In fact, we have agreeable to a point, the point done. I don't think it will take more than half an hour. No.
Let's try our luck on Thursday 2 PM.
Yes, Lords.
Let's this matter on Thursday 2 PM.
Obliged.
No more any earlier matter, huh? Oh, I picked Monsoon Enterprise. Oh, that too I was dismissed, na? It's okay. We can have it on Friday? No, Thursday, not possible. No, these type of matters doesn't take much time. These are tender matters or something, na? He has, what was his problem?
Rejected my friend, technical bit there it is.
On what ground?
On the ground that, no, not, there's a ground there that you have not a particular, it was fixed that you have to do a work of certain amount. That amount is not there in your document. In fact, that OEM has that particular amount. Because there's a cross fight, it has to be between the OEM and the.
There's a stay also, na?
Very distinct. Lots will extend the stay and lots will fix it on 22nd Friday of Friday. 21st.
Hello? List this matter again, and we'll have it next week some other on 28th of August. Interim order pastorally shall continue till then. You are there, Mr. Gogoi. This item 10. Huh?